as we initiate chaos. Theory guarantees that we'll play like lightning shots, sounding like thunder. For every time in the face that it hits us, we're faster. Well, they should know by now. They see the world keeps trying to shake us. It only waits us. The pendulum swings. The pendulum swings. It's in a beautiful darkness. Only another. It's full steam ahead. Full steam ahead. All about the Petty Express. Misdirected from the start. It's a runaway train. I come a freight train. I come a freight train. In a beautiful darkness, the Petty Express. In a beautiful darkness.
Good morning, everyone. Welcome to the Petty Express, and we are pulling out on a brand new trial. This is Georgia versus Christopher Wolfenbarger. I am probably going to butcher that name about 9 ways to Sunday before even the first 30 minutes are through. So I'm basically just going to be calling him Christopher for the duration. Now, this case started all the way back in, goodness gracious, 1998, around Thanksgiving time. Melissa Wolfenbarger basically disappeared. Her family, tried to find her, tried to look for her, but since she was, an adult at that time, even though she kind of left, her 2 children and her husband behind and didn't leave any information with the family, there wasn't a whole lot that the police could do, and not a lot of information surfaced. Now, she was last heard from around Thanksgiving, and unfortunately, remains were found about 5 months later that were misidentified as male remains close to where her husband worked. Now, it wasn't until 2003 that the remains were identified as Melissa. And that was only after her father, Carl Patton, was arrested for a string of unrelated killings from the 1970s, known as the Flint River murders. So this is a crazy case. It involves, a cold crime, a possible DV or, relationship violence. And then it also has, a serial killer and a lot of different things, as well as a podcast, Zone 7 by a fairly large and well-respected criminalist who kind of got the ball going on this cold case being, re-looked into to get the kind of confirmation of what the family had long suspected after the remains were identified as Melissa, that Melissa's husband, Christopher, had something to do with it. Now, it took a long time, but he was arraigned and Christopher is on trial. Now, currently, they are on day 4. We are going to try to really stream through this, watch at 1.25. I will have the closed captions on and skip the breaks. Glad you're no relation, Wolfram. And we will try to catch up. Hopefully this weekend we can kind of get to where we're on maybe just a day behind by that time, hopefully. So let's get into this. We're starting day 1, Law and Crim. So let's do this. I've got things boosted and the closed captions on. Now, this is out of Fulton County, so Fannie Willis, the YSL, and Adrian Love. So we will try to see if if this courtroom is as crazy as that courtroom. Now, our own Nicholas Starro did a lot of work on that trial, and it was a long, long haul. Okay, just first initial impression, I'm pretty sure I saw this guy on Twin Peaks and it freaked me out. That being said, optically, from a first impression point of view, I will say there's something off-putting about him that I can't put my finger on. That being said, everyone is presumed innocent, but if I'm just going with I don't know this person. There is something a little bit unsettling about him to me, but you guys know I am not the barometer of normal because I am an inside cat to the extreme. So regular peopling is creepy to me. So I am not your barometer of, look, I profile everyone at Walmart. That being said, I do think that they've got him dressed up pretty nicely. I'm not sure what his hair is doing, but and I wonder if we're going to learn anything about his medical history that would require him to be in a wheelchair. Sorry. I love it when I try to eat a piece of my own hair like I have pica at the moment. That being said, my research into this case was the grand total of the time I put in to find the article and give it to you for the intro to this particular case, the Christopher Wolfenbarger case. So I have not learned the ins and outs of this. I have not listened to Zone 7, the podcast that has kind of been touted as, really pushing this case into, even to trial. That being said, let's get into this together. If I did put out about a 17-minute video about this case, and it is a fairly long article, so it does take longer than 10 minutes, but it should give you a good grounding in this case. What I've given you is the shortened version, but with so many characters and such a long period of time before this case even came to trial, it can get a little confusing. But let's get into this. And nice ponytail, lawyer dude. Very, very. I wish my ponytail would ever look as slicked back as that. I swear to goodness, men are blessed with good hair that they don't appreciate. Just sadness.
Okay. Madam Court Reporter, you ready? Yes. Okay. This is going to be day 3 of the trial of Christopher Wolfenbarger, case number 24 SC 004201. I'll note for the record that we seated our jury yesterday and that they are filtering in ready for a start time of 10 a.m. Mr. Wolfenbarger is present here in the courtroom along with his counsel, Mr. McDermott and Mr. Samuel, and the state's counsel, Mr. Fawcett, are also present. We had some preliminary matters that we needed to address this morning. I had wanted to follow up on audio and photographs that we were still working through in terms of what's going to be offered. Mr. McDermott, had you had a chance to get through those materials?
I have, and I emailed Mr. Fawcett last night.
Okay. Do we have agreement on what's going to be offered?
We do not, Your Honor.
Okay.
I did take out photographs that defense counsel felt as though they were duplicative. I took out photographs that displayed the victim's skull.
And if you are new to this trial, the victim's remains were in pieces, to put it as mildly as I can. So her head was not found with the rest of her body, and her torso has never been found. So this was a quite grisly case. And I can imagine that this late in the game, after jury selection has already happened, that this is going to be, this is kind of late for these, photos, any sort of electronic data to come into a trial. So I imagine we're going to get a good amount of argument or at least discussion between the lawyers as to how they want to deal with this, because photos, especially of grisly crime scenes, can be more prejudicial than probative. And that is sort of the line that the judge has to use to judge whether, a piece of potential evidence can go into trial or it's going to be too detrimental.
There's one that displays the location of the skull. There's several others that show different angles of it. I've eliminated those as part of my intent to show the jury the location and corroborate the evidence in the form of testimony. But this is a case where Ms. Wolfenbarger was, her remains were left. We know at least the extremities were out there in the elements for at least a 2 to 3 month period, because you have the skull found in April and you have the extremities found in June. And so that just by the very nature of that is going to lead to pictures that are less than pleasant. But there are only 2 photographs of her extremity that were located in the woods on that June date. Obviously, there could be several of those photographs, but there are only 2. The autopsy photographs, we have eliminated several, and the intent of the autopsy photographs is to show some tool marks. But we anticipate testimony from our anthropologists as well as our medical examiner to say that they observed, they believe, some type of mechanical device, man action, that was used to separate the skull from the neck and the femur bones from the torso. And so all that's relevant evidence and the markings on that show the jury the marks that would be testified to, as well as corroboration of testimony. And I would submit to the court Davis versus the state. That is a Supreme Court case, 306 Georgia 140, 2019 case, specifically deals with defense objections as to the gruesomeness or objectivity, prejudicial effect of crime scene photos and homicide cases.
Yeah, and I mean, and let me save y'all some trouble. I am not of the opinion that just because things are gruesome that they are somehow prejudicial. If they're relevant, then the court will conduct an analysis under the appropriate rule of whether it's overly prejudicial as
Praise be to the Lord above and all that is holy, a judge that knows where her mic is and can speak authoritatively. Holy Fazoli's, this might be a miraculous case.
is required. I think what I was hoping for is more to avoid accumulation, right? And so that what you're presenting is the evidence that's necessary and relevant to your case, and not, let me show you 9 pictures of the same gross thing that we all really don't want to look at when maybe 1 or 2 would suffice. That's really all I'm trying to accomplish here. And if you're going to show 9, I want to make sure there's some particular reason that that's necessary and that I've conducted the analysis I need to ensure that it's not overly prejudicial if that's what you're doing.
Well, if I can split these up, and I'm
Sure.
going to start with the autopsy photographs.
Okay.
If I'm looking at the autopsy photographs, the intent was to show each different section of the body that was discovered, as well as the tool marks that would be testified to.
Okay.
I do not believe there are any duplicative photographs of any one particular part of the body that was located. I don't believe there are any duplicative photographs of any of the tool marks as it relates to the images I intend to show from the autopsy photographs. As to the crime scene, obviously there are going to be photographs of what the crime scene looked like without the body there, because the body was, transported with the remains. But it's important for the jury to have a context of where the location of the skull was located. There will be some testimony that they believe that there were dogs that were carrying the skull, or a bag they believe the skull was in, from the wooded area where the extremities were located to the street where the skull was found. There's going to be testimony that that same dog had to be shooed away. And I think that as far as where the skull was found, where the sewer is, and the proximity of that to the job, I think is particularly relevant. And I think specifically as it relates to that Davis case, specifically crime scene photographs that are indicative of the location of where relevant items are pertinent. And although they may be prejudicial, I hope everything that I present is that prejudicial effect is not outweighed. I think that this evidence is relevant, and I think it is necessary for the jury to see some of the photographs. And I mean, I guess ultimately what I'm saying is, I don't have any issues taking direction from the court. You're the fact finder, so if you independently feel as though a certain portion of the photographs don't need to be played, that's fine. But what I got from the defense, I think, was limited in what they were willing to agree to. I didn't feel like that would have been representative of the case.
Okay. Thank you, Mr. Fawcett. So, Mr. McDermott, let me ask a couple of questions as you begin your argument. So, I'm assuming for your record, you want to state your objection to all of them. Is that fair?
No.
No. Okay. Well, then, because really what I'm trying to get down to is if we assume that some universe of those photographs are going to come in, then what I'm trying to get to is what are the particular aspects, which particular photographs do you object to and why?
Well, I sent him a list last night. It's my understanding he was going to submit all that to you and go through them one by one. But really what he described is actually what my point was. I'm not objecting to showing a head in the road as it was found. I mean, that's obviously relevant and important to the crime scene. As far as the discovery of the limbs a month later, there are only 2 pictures of that, one limb and one black bag. Well, I take that back. There are a couple of other black bags. I don't object to those. When we get to the autopsy photos, I understand we need to show tool marks because they're going to testify this was assault, and we'll have a discussion about that. But do we need to see this is the left foot? No tool marks involved. Nothing about the crime scene. Nothing about cause of death. Nothing necessary to explain anything the medical examiner did.
So,
And then now the right foot. Well, let's look at the right elbow. Let's look at the other.
right, no, I understand that, Mr. McDermott, but I mean, setting aside that we're talking about body parts instead of one entire body, I mean, it is fairly standard to show for identification purposes, this is the body that was delivered to us, and after we clean.
And I would think it would be all the more important to show these disparate body parts when you have a case of disarticulation. So when you have a dismembered body, you, I would think, have to show that both feet look similar, that, you know, you compared, I'm not a embalmer or a ME, but however you did, you know, make sure that both limbs were the same from the same person, I would imagine that it would be, in fact, more prescient to, you know, show all of these kind of mundane pictures in a case like this when you don't have a torso that kind of joins up all the limbs. I don't know.
Up the condition that it was in. And usually the arguments I'm having are, but please don't show where you took off the front of their face to inspect their brain. And so I guess if that's the typical way that it's presented, then why would, here's the left foot, here's the right foot, here's the right arm, here's the left arm, here's the skull, at least those minimal baseline photographs, why wouldn't they be admissible? Why would they be overly prejudicial or not relevant?
I think the repetition of it, but in addition to that, we have multiple pictures of bones after the flesh was, as we understand it, steamed and cooked off of it. That's not necessary for them to determine anything. The tool marks were visible without that. Why do we need pictures of the bones laid out in an array? So if we could just limit it to what is absolutely.
Now, if you do remember the Chandler Halderson case, this was something they also did in the Halderson case. For anthropologists to be able to get a really good look at the tool marks that might be left on the bones of a victim, they do have to clean them, for want of a more, well, gentle euphemism. So those might be needed. That might be something that the anthropologist is going to be using to present. So I understand what he is saying, but this is not something outside of the realm of normality on other trials that we've seen.
Absolutely necessary to get it across.
Okay.
I think that would be helpful.
So to that end, forgive me, I'm going to let you continue making your record, but to that end, I think what needs to happen then is, Mr. Fawcett, if you have a list that was provided to you for Mr. McDermott, if you can just email that to me so that I can take this flash drive. Are the exhibits identified by exhibit number on this flash drive, Mr. Fawcett?
Yes, the exhibit numbers are listed on the exhibit.
Okay, so I should be able, what my intention is to go through and look at the ones where Mr. McDermott has asserted an objection, where the parties don't agree, and then just go through, and then I can go through them one by one and provide you with rulings on their admissibility.
And let me just add, as far as the flash drive goes, it's one PowerPoint file, and the numbers of the exhibits correspond to the numbers of the slides in PowerPoint.
Thank you. That's very helpful.
I just also want this put on the record that there's I don't know what to call this. This is a printed out list of photographs that was included in the original discovery. I have never been able to find out who created this document, and we have never been provided with these photographs. There are multiple photographs.
Fulton County, you don't say. Discovery issues, you don't say. Yes, for those of you that are just coming in, this case is out of Fulton County of Fannie Willis fame. So if you happened to catch any of the YSL trial that Nick Starro and a bunch of other people covered, that was a cluster truck, and the defense having issues figuring out where the state, you know, transported discovery from is not, well, it wasn't outside the realm of possibility. I really need to get a current, like a day one bingo card. State loses discovery. I'm gonna work on that. It'll probably be a Petty Express day 2 before I figure out the bingo card, but we'll play along together because I think this case could fill out multiple bingo cards.
Describing the crime scene where the limbs were found. And by my just looking at it, probably about 36 photographs. And I think that would actually be more helpful than the autopsy photos. But I would just love to find out who compiled this list so I could cross-examine them. And I've been asking for that for several days now. Don't get an answer, so.
Okay.
Put that on record.
Mr. Fawcett,
Yes.
you're gonna email me the list that you and Mr. McDermott have exchanged?
Yes, Judge, I just did that.
Okay.
You should get that. And I think when we first started at the arraignment for this case, I know the court referenced how old the case was and how sometimes there may be documents that may not be able to be produced. When we first indicted the case, we went over to the Atlanta Police Department, the annex, to retrieve and physically view the files. Before the case was indicted, I went over to the Atlanta Police Department and reviewed the officer's original file. We did that again a month after the case was indicted, just to ensure that we were complying with the court's discovery request. I believe that was required for the end of that year, I think 2024. And shortly after that, we got a request from the defense. I offered for the defense to come to our office to view our discovery. I think after we had the motion to compel, I advised the court that I had offered them to do that. I made another offer to do that. And I made a third offer in writing, emailed to Mr. McDermott, I think maybe 3 weeks ago. Last week, Mr. McDermott emailed me and asked me what day would be a good day.
J.K. DeBuck, I honestly have no idea.
And my intent was to make the Atlanta Police Department lead detective's file available, Detective Shepard. My intent was to go back to the annex. I know how important this case is. Go back to the annex and look at it again. Part of doing as much due diligence as I could. I offered Mr. McDermott, I believe Tuesday and Wednesday of last week, to come over and view it. When we talked, we discussed the discovery. We didn't discuss that date. I assumed he no longer was interested in that. But I've looked at every file that we've had. I've looked at the annex. I've looked at our digital files multiple times. And every document that we have in physical paper form and digital form has been turned over to the defense. I don't have any other documents.
Okay.
My complaint is not that I don't have enough documents or that these photos are missing. I can understand that that's the case. I just want to know who made this document and can I call them as a witness? And that's not unreasonable. They have access to Mary Beth Hoptel. They have access to T.R. Miller. They have access to all the investigators who worked on this back in the Calhoun days when this would have been created. And they can surely find out who created the list of photographs and their descriptions so that I can cross-examine.
And yeah, I did inform counsel that there were 2 investigators that were working on this case. It was Mike Alsop, whose name is in the discovery, whose name is on several.
Hang on, let me back up for a minute. Do you know, is the issue that you don't know who created that document?
I don't know who created that document, but I can say that
Right.
there were
Okay.
2 investigators that could have created it.
Sure.
Mike Alsop, who was an investigator with the Fulton County Medical Examiner's Office, and investigator Tina Miller, who is on the witness list.
Doggone it. I keep moving my... All right, we're just going to have to go to the regular old, backup. I keep trying to move my face so I'm not in the way of anyone talking. It's just not my day. Sometimes it's just not going to be your day. Doggone it.
Who's also an investigator. That's an investigative report, and there was one of those 2 investigators made that report.
Okay.
I mean, I guess I can wait till she's on the stand and roll the dice.
Well, have you had an opportunity? I mean, I assume those individuals were identified to you either specifically as people with information
Yesterday.
or on documents that were in the file in terms of reports that would have been provided through discovery of their involvement in the case.
I mean, they have been on the state's witness list.
Okay.
But as far as their involvement with these documents, I didn't know. I learned that yesterday.
Okay.
I still have time to try to call them between now and then, although I think T.R. Miller's scheduled to testify today. So.
Okay. So here, I think that if the state has identified that they don't know who created that document, but that it could be either 1 or 2 people, and those people are identified as witnesses, or through their role were identified in terms of their involvement in the case, that they've been identified sufficiently for purposes of discovery, and that to the extent that one of them is going to testify, I don't think it's unreasonable for you to ask to, inquire with them before they take the stand. Hey, is this a document that you created?
Go ahead. Those names were mentioned to me yesterday. Mm-hmm. I was not told, we don't know who did this. You'll have to pick from these people and find out for yourself. I was not told that they didn't know. I was under the impression that they were still going to try to find out for me.
Well, I understood from Mr. Fawcett's answer that he did try to find out, and he hasn't been able to find an answer, that it's got to be one of these 2 people.
Then there was
But
some communication yesterday.
Well, Your Honor, I think co-counsel has a suggestion. I'll reach out to the original detective, Calhoun. I'll forward these to him to see if he can assist. He may have the name of a crime scene detective who would have created that document.
Okay.
I'll do that.
Thank you. Anything else on the topic of photos for now, Mr. McDermott?
Not those photos.
Okay. Well, there were two sets of photos we were talking about. One was the list of photos that has not been produced to you, that Mr. Fawcett says do not exist as far as he's aware, digitally or in paper. And then there was the second set, which are the ones on this
Good morning.
flash drive that I'm going to look at and rule on. I have now received Mr. Fawcett's email regarding the ones they intend to offer that I need to actually look at in terms of your objection.
Pretty much.
Any other issues on photographs that we need to address?
I'll just say yes because Mr. Fawcett just gave me this morning a stack of new discovery. And, well, about half of this is stuff that's old discovery, and about half of it is new discovery that would have been nice to have even just a week ago. But these are cards and letters and photographs written between Norma Patton and allegedly Melissa. And, I mean, it's just dumped on us right before trial, so that's a discovery.
Now, Norma is Melissa's mother, so this is a crazy, crazy case. You have a cold case of nearly 20 years, a serial killer, and, dismemberment. It's all crazy. But at the bottom and heart of this case is Melissa Wolfenbarger, who, her family never saw her after 1998, around Thanksgiving time. She, according to Christopher, her husband, who is at the defense table, she left her kids, left her husband, and moved out to California to start a new life. She was, swinging single and free, and she was in California. Now, her father, her mother, and her sister, family members didn't really buy this, but they couldn't really, get any more, contact out of it. Now, 5 or 6 months after, she is not heard of or seen from again, there are remains that are found very close to Christopher's work. Now, these remains, because there was not a head with it, JKD Buck. No, he didn't have family ties. So about 5 to 6 months later, body parts show up, but it's an incomplete body. And because of the lack of a torso or a head that was found at the time, they misidentified these as possible male remains. And the case kind of went cold, both with Melissa and these remains. Well, in 2003, Melissa's father, I believe his name is Carl Patton, was, convicted of 4 murders that were unrelated to this event in the 1970s that were called the Flint River murders. So with him being charged with those murders, it did come back with a link to these remains that were found, and he was actually charged with his daughter's murder for a little bit until, it was found out that he was most likely not her killer. So he was, convicted for those 4 homicides in Flint River, but the charge of his daughter's murder was taken off of his, kind of charge sheet. Now, the mother then went on to try to find some sort of resolution for her daughter. She eventually ended up running into a crime scene analyst who kind of went on to start her own podcast about cold cases, and they featured Melissa's case. And she was able to get a couple leads that actually took this case from being a fairly cold case to where we are now, where her husband now, some 26 years later, is on trial for the taking of the life of Melissa. Now, this was a really grisly crime scene. She was obviously disarticulated, so we're going to be doing kind of a lot of Chandler Halderson sort of testimony with, anthropologists and tool marks. But it also does intersect with, DV. So there's a lot of, there's allegations that Christopher was abusive to Melissa and that she had tried to leave him in the past and unfortunately had gone back to him, and then maybe, wanting to leave again might have sparked this whole incident to start. But that's basically what this case is. Now, it is currently on day 4. We are just starting with day 1. So we're actually hitting this, relatively quicker than we do other Petty Express. But after that too long didn't read, I do have a longer video that has all of sort of the facts and background of this case that I put out this morning. If you need a little, about 15-minute video to explain this, but let's get back to this. We are going to try to run this at a quicker speed. So 1.25, talking and through the breaks, through the lunch hours, that kind of thing. If it's too fast, let me know. And this is going to be a rough case. It's going to have that. So if you need a puppy and kitten break, let me know that too. Let's get on with this.
Violation, in my opinion. I've heard tale of these cards and letters for ages now.
I believe I heard you during pretrial argument say, where are those cards? Where are those letters, right? So.
Recently? Yeah.
On Monday during pretrial, when we were talking about statements by.
It's nice to have an answer to my question. I agree.
And since this is Fulton County, I'm only relying on the YSL trial that I kind of, pinched in and helped Nick with every once in a while. Discovery issues from the state's attorney have been numerous and rife. And I hope that this doesn't derail this trial, but it seems like it is already on track to derail this trial.
But still a discovery violation. That should have been turned over if they existed, which they did. That should have been turned over a long time ago.
Okay, and we can talk about that when you're ready to talk about that. But those aren't photographed, and we're not talking about that just now.
Well, there are photographs in there. So.
Okay. But I'm assuming not the graphic ones involved in Ms. Wolfenbarger's death.
It doesn't pertain to the I'm sorry, that's my fault, and I'm being a bad boy. I just admit.
I'm a bad boy. Not one ever again, sir. Just never, ever again. All right, let's try this back at the original spot. I do find that I'm vain enough to want to see my face a little bigger, mostly because I want to make sure that my, eyeliner doesn't become my eyebrow. That's the level of vanity that I have today. But then let me move these up here, and I think we have figured out where I'm going to be placed today, possibly in theory. Let's continue.
That's my fault. You said any other photograph.
Sure.
I made that jump.
That's fine.
Good to see you.
What about the audio of Mr. Wolfenbarger's statement? Have we agreed on the portions that will be played for the jury?
I think we have an agreement to maybe 80-90% of it. There's a portion we've agreed to start at 15 seconds earlier. I'm agreeable to redacting a part in the middle that counsel has requested. There's a part towards the end where the lead detective is asking a question and he is indicating his theory about where the skull was possibly washed out of because it was framed in the previous day.
The detective is saying that?
The detective is saying that to Mr. Wolfenbarger, and Mr. Wolfenbarger responds the way he does. But I think there's other evidence that the skull is likely dragged out of the wooded area. So the counsel is requesting to be redacted. I don't think it needs to be redacted. I think of scenarios where officers ask and make all types of statements to defendants to elicit a response or see if there is a response. I don't view that as any different. If Detective Shepard and Detective Layton are asking Mr. Wolfenbarger a question, even if they are misrepresenting the crime scene, courts have said that it's not to say that was the intent of what was happening. Courts have even approved officers lying to defendants or suspects. So I don't think that this is a situation where that was taking place, but certainly, even if the crime scene was not in line with other theories, question about that the defendant shouldn't be excluded just because it may not line up with other theories. It still elicits a response from the defendant that I think can be relevant for the jury to consider.
Mr. McDermott?
Yeah, my concern with that particular statement is not that it's just some random theory of the detective. He's not telling a lie. There are some speculation in the early police reports that there may have been a weather event that washed the head out into the road. It clearly was picked up and used by later detectives. For example, Detective Shepard has used that theory when speaking not to Mr. Wolfenbarger, but to other witnesses as explanations for how the head may have gotten there. So clearly this is something that was important to the investigation, and they weren't treating it as a lie to try to get a reaction. And particularly Sergeant Layton's statement in that video is correcting or trying to help Christopher with his understanding at the time, and he says, "It is my understanding that there was a strong flood of water that washed this out into the street." So that's how it got there. And he says it in such a way that I'm afraid the jury will take that as evidence that something happened. He says it in such a confident way that it's his understanding. I think it will confuse the jury.
Is that individual going to testify?
There are two individuals there. The Detective Layton is not scheduled to testify, but Detective Shepard was there. He's on the video. He introduces himself to Mr. Wolfenbarger and is present throughout the entirety of the hearing.
Okay.
So that was my second point I was going to make, is that Sergeant Layton is not on the witness list, and he's not going to be available to testify on that point. So I just don't want the jury to get confused about that. So at the very least, if we don't redact that, if the court would provide some limiting instruction on that point.
I'm not sure what the limiting instruction would be. It seems the
Yeah, I don't think you can limit, it's my understanding. And again, that's a kind of individual juror to individual juror thing that, whatever, and it's also an individual juror question, whatever weight that they put on the officer's statement. Again, they might choose to, take the officer's word as authority, but I thought that was something within their right as a jury. I know, I love to nerd out on this stuff. I love it when they play mental chess with each other.
reason I asked about whether the witness or some witness could testify about the circumstances of that statement, certainly with knowledge of the investigation, is that seems like a topic for cross-examination in terms of whether that was accurate or whether you have information indicating that it was accurate. So I am going to the extent there was an objection as to that particular question, I haven't heard anything that would require it to be removed currently. The objection, as I said, is more subject to a subject for cross-examination of a witness that would testify about those conversations. Given that ruling, if we then have sort of a universe of agreed upon audio, if y'all can please reduce that to some secondary exhibit, which will be what's played for the jury, with only those items that either the parties have agreed or I have ruled will be admissible, that can play as continuously. And then, as I said, when we're ready to play that, I will instruct the jury that there may be jumps in the video. There may be things, it may appear to them that things have been removed or that it's been edited and that's been done at my direction, and that they're not to draw any conclusions from the fact that things have been removed from the video or audio, and they're not to speculate about what might have been removed when it's time for that to be played. What exhibit is that going to be, Mr. Fawcett?
That is going to be, and I do have a list for the court. I just wanted to see what the ruling was. Let's see. That is going to be Exhibit 30.
And so y'all are going to have an Exhibit 30A, which is just the relevant portions that we've agreed on. Is that right?
You can do that, yes, Judge.
Okay, thank you. As I said, I'm just trying to avoid I'm going to start it and stop it, and then I'm going to start it and stop it, and we just have something that we can agree to play. It is more efficient. Okay, couple of other issues. So I have spent a good bit of time with the forfeiture by wrongdoing issue that was raised by the defense. Specifically, I've already ruled that non-testimonial statements that Ms. Wolfenbarger made to family and friends, that those family and friends can testify about those statements. There is the secondary issue, though, was that there are statements, as I understand it, there are statements made by Melissa Wolfenbarger in court records in service of a TPO application and to police officers as part of, I think, an investigation into that initial event that occurred, I think, on Brookline Avenue, if I'm remembering correctly. And that those are, I think everybody agrees, those are testimonial in nature, and therefore they implicate the confrontation clause. And the state's argument is that those statements, that Mr. Wolfenbarger has waived his confrontation rights as to those statements because of his wrongdoing in causing the absence of Ms. Wolfenbarger. So as I understand that provision, it isn't just that the defendant, that the state can demonstrate by a preponderance of the evidence for purposes of the application of this exception, that the state can demonstrate by a preponderance of the evidence that Mr. Wolfenbarger may have caused Ms. Wolfenbarger's absence. It's that they have to demonstrate that second piece, which is that the purpose of the causing the absence was to prevent the testimony. I don't have it up right now, but what I located, I looked at a bunch of case law. The most recent one I saw was from Judge Dillard.
This is actually a really good judge who is taking all of this. This is a very complex case. It's been 26 years in the making. It also involves DV issues, so intimate partner violence issues, along with, I believe they were looking to separate, or Melissa was looking to separate from Christopher at the time of her disappearance and possibly get an order of protection. So these are things that, since Melissa is no longer alive, the defense cannot, confront her or any of her statements. So this is going to be very important. And I'm glad that the judge is taking her time and really looking at this.
In the Britton case. And I found that to be particularly educational, because what Judge Dillard does is spends about a paragraph explaining the circumstances of that witness going missing. And that was satisfactory to the Court of Appeals, that the defendant may in fact have caused the person's absence. But then importantly, they add a sentence that says there was evidence in the case that the defendant had made a statement to, I think, a cellmate, that the defendant was not worried about that witness testifying. And I think that's the concern I have here, is that we have evidence that the state absolutely can satisfy by a preponderance of the evidence that Mr. Wolfenbarger may in fact have caused Ms. Wolfenbarger's absence. What I'm not sure I have is evidence other than potentially an inference from the circumstances, but that inference has to be reasonable to satisfy the preponderance standard, and I'm not sure I have enough. And so based on what I have heard so far from the state, I don't believe that they've satisfied the burden to demonstrate the forfeiture by wrongdoing standard. And so, as I said, to be clear, I believe they've satisfied and demonstrated by preponderance the evidence that Mr. Wolfenbarger may have caused Ms. Wolfenbarger's absence. But I've not heard evidence that either establishes or from which the court could draw a reasonable inference that the purpose of that absence, the purpose of his alleged action in causing her absence, was to keep her from testifying against him in the domestic violence or TPO matter that was pending at the time. And so that's going to be my ruling. Mr. Fawcett, do you want to make a record regarding that issue, sir?
Not necessarily, Judge. I accept the court's ruling. I do have several that are certified that are representative of that criminal case, such as the petition. There's a Rule 9 sign setting the court date down. There's an order restricting contact, and then there's a request for dismissal by Ms. Wolfenbarger. I still believe all those documents are relevant, but I would still be asking the court to allow the state to tender those into evidence. I would not be publishing the portions of those documents where Ms. Wolfenbarger's laying out the testimonial statements.
Right. Well, I'll hear from Mr. McDermott, but on its face, I agree with you that the existence of that case is not a matter, it is subject to a different hearsay exception that would allow potentially its admission, and it would seem to be relevant. But we were talking specifically about the statements of Ms. Wolfenbarger to officers and or in those documents. Mr. McDermott, your thoughts on that issue, sir?
Well, we would like to see his proposed redactions.
Sure.
What he wants to do, and be able to talk about that perhaps over lunch.
Mm-hmm.
And go from that point.
Okay. I mean, I'm not ruling that they are admissible because no one's asked me specifically, but as I said, at first blush, I tend to agree with you that those would be relevant and potentially admissible under different hearsay exceptions. Anything else there was a motion in limine that was filed by the state, I think last night. And I need some help with it because I wasn't quite sure I understood what we're trying to limit. Obviously, we've understood for some time now that the fact that Carl Patton is a convicted murderer, right, was going to come into evidence in some manner, right, that was going to be an issue in this trial. So I'm not exactly sure what you're asking me to allow or to forbid. Can you help me, Mr. Fawcett?
So I guess it's laid out in the motion. This is, as of the past week or so, I think it kind of gives me some insight into what possibly could be asked or attempted to elicit during the course of the trial. And as I've laid out, the only reason why Ms. Melissa Wolfenbarger's father is relevant in this case is because his arrest really jumpstarts the identification of her. And I don't know when she would have been identified, but for the infamous arrest of her father and him saying, "Find my daughter." That's pretty much what we've heard repeatedly by the medical examiners, the lead detectives, and everyone involved. But to take that information and now to attempt to introduce letters from Carl Patton, what I'm trying to avoid is a relitigation of the case involving the Flint killer, because all the particulars of that case simply aren't going to be relevant for the determination of whether or not Christopher Wolfenbarger murdered his wife. So it's one thing to say, well, he was arrested. It maybe is relevant what he was arrested for, maybe. But outside of that fact, And the fact that that arrest triggered the identification, that's what the detective, Bruce Jordan, was the notifier to the medical examiner's office of that missing woman, Melissa Wolfenbarger. That triggered the retrieval of the dental records from William Brantman. And that was the comparison that made the identification. So outside of that, what other relevant parts of the case would be admissible? I don't believe that the statements of Carl Patton would be admissible. I don't believe that the particulars of the case itself would be admissible. So I don't believe that the defense should be able to ask Norma Patton, well, tell me how many people did he kill? Tell me the circumstances of that. How is that relevant for whether or not Christopher Wolfenbarger killed Melissa Wolfenbarger? It just is not. And I think that in particular is something that confused the issues in this case and confused the jury.
Okay, Mr. McDermott?
We disagree, Your Honor. We think that the only point of relevance being that he helped them identify who she was is just the tip of the iceberg. There's an entire developed body of case law which has been even more developed recently by the Supreme Court regarding evidence of third-party guilt. This is a classic whodunit case. The state has only circumstantial evidence that Christopher led to the death of Melissa. We have substantial evidence that there could.
Okay, so this is making more sense why they want more of Carl's, MO, what he did in his past. If you are new to this case, Melissa Wolfenbarger, the victim in this case, has the unfortunate happenstance, I guess, that her father is a quadruple, red rummer. And basically what jump-started this cold case into the trial against Christopher was that Carl, was linked to these missing remains that came back as a DNA hit, turned out to be his daughter, and the police investigating Carl's case, and I haven't dug into Carl's case, so I will be doing that this evening. But it looks like they were able to clear him of Melissa's death, and then scrutiny started falling on Christopher. That being said, this is going to be a crazy case, so I can understand why the defense is wanting to use this as a third-party culprit. I mean, the father has already been convicted of multiple homicides. What is to say that he didn't also do this? I haven't, watched enough of the trial to have an opinion either way, but this is something to keep in mind as to what this is a strategy is going on, that the defense is looking to possibly implicate the father.
There have been other people who were involved in her death. And the Supreme Court has recently said the standard for third-party guilt is basically going to be 401, 402, 403. And they have telegraphed that in their most recent opinions. Even though it's not the precedent, I'll grant you, they've telegraphed that. They've said the test is going to be, if this evidence makes it likely, tends to make it likely, using the relevance, I got the top of my head, the rule for relevance, more or less likely that he's guilty,
right? Yeah.
then it's relevant. And then it's only a 403 test after that. Well, Carl Patton's murders, it's not just he killed 5 people back in the 70s and that was it. It's why he.
I apologize, but 5 people, I misread that. I read the article at 4 a.m., not gonna lie.
Kill people. It's his motives for killing people. It's who he killed, his friends and family, the way he killed them, wrapping them up in bags and dumping them in the river. It's the fact that he drove miles and miles to try to hide bodies. It's the fact that Norma Patton, who's going to be testifying here today, was right there hands-on helping him for 2 of those murders. She helped him. And what I intend to ask her about is only what she testified to in court. It's a certified court record that she helped. She helped plan the murders. She helped watch. She was in her living room. They shot the people. They fell. She helped clean up the blood. She helped carry the bodies out.
So let me stop you for a second and set what I think are going to be 2 signposts here before we get more granular, right? One is the fact that Mr. Patton exists, that he is a convicted murderer, that he, I think, was briefly considered a suspect, although my understanding is obviously the state changed its mind and decided that it wasn't Mr. Patton. But all of those things are relevant, and I think that the state can't limit the relevance of Mr. Patton's existence and his history, right? Like how it's relevant to Melissa Wolfenbarger as a general proposition. Also, certainly, I fully expect that if Ms. Patton, Norma Patton, takes the stand, that there will be a thorough and sifting cross-examination about her involvement as a credibility matter, right, and as a convicted felon or whatever, you know, charges she pled to. All of those things I think are absolutely going to probably come into evidence. As a general proposition. What I'm concerned about is that part you were just talking about in terms of satisfying 403, from a basic relevance perspective, and to avoid getting too far afield of the issues in the case is, my general feel is I don't really want to get into relitigating the circumstances of the murders that Mr. Patton committed unless you can show me the specific reason that they would be relevant to this issue. And right now we're just having a general argument and you're just making a proffer, but that's what I haven't heard.
Well, I would reiterate the points that I just did. They're certainly relevant to how these bodies were disposed. They're relevant to who was killed and potentially why they were killed. There's evidence that Melissa knew about Carl Patton's murders, which is something he kept under tight.
But again, that's the fact of the murders, you're talking about the circumstances.
It's a motive for the murders, and it would be a motive for this murder as well. That's evidence of third-party guilt. It's relevant.
Mr. McDermott, I think we're talking past each other.
Okay, I'm sorry.
I'm not saying that you're right now, as a baseline guidepost, general proposition here, I'm not saying that I expect the defense is not going to talk about the fact that Carl Patton is a convicted murderer. And I'm not saying that you're not going to cross-examine Ms. Patton about her involvement and that sort of thing. I'm also not saying that the fact that he's a convicted murderer might have some relevance to this case and whether Melissa had motive, or whether that might have formed some motive for Mr. Patton to be this alternate theory of the crime murderer, right? That's not what I'm saying. What I'm saying is I understand Mr. Fawcett's argument to be, it sounds like you want to go in and let's have a little mini trial about the circumstances of each of those murders. And that's what I'm trying to figure out. Why would anything other than the fact that he committed murder, right? Even the numbers, even the names, but why would the individual circumstances of those offenses, other than potentially some leeway to cross-examine Ms. Patton, Norma Patton, why would that be relevant?
Well, can the court help me out here? Mm-hmm. When you say, oh, I lost my point, I'm sorry.
Sorry.
In the last thing you said, obviously we would agree that the fact that he committed murder is relevant, but you're saying what more than that is relevant? You're asking me what beyond that would be relevant in this case. And I think anything that okay, let me go back to the point. You're saying we don't want to relitigate this case, and you hear me trying to relitigate the Flint River.
Yes.
What part about me reciting the facts that are on court records in a guilty plea hearing, what part of that is relitigation? These are just facts about how those murders happened, what their motives were, who they killed.
I mean, in my opinion, if the Carl Patton case, and again, I will have to look into these, but if they follow a relatively similar victimology as Melissa, then that would be probably something that the state, I hope their investigators, tied this loophole up, explained how, Carl couldn't have done it, that Carl was in jail or, in Florida, something that makes it so that Carl isn't a potential third-party suspect, because, the defense lawyer is arguing out or making cogent statements and a fairly well-reasoned argument. If Carl Patton was known to target friends and family, then the familial connection of Melissa being his daughter might not be a limiting factor. If there was disposal with black trash bags and you have black trash bags here, I mean, again, not a lawyerologist, but I would assume that those would be germane to the case.
Those are facts on record, testified to under oath. There's no litigation happening. But those are facts on record that are relevant to the facts that'll come out in this case. And that is directly relevant to third-party guilt.
Okay. So, Mr. Fawcett, as I understand the state's motion, it was an effort to limit the nature and scope of evidence that will come in about Mr. Patton. Is that a fair general characterization?
Absolutely, that's correct.
Okay. So,
and let me just say this, if I may.
Sure.
I sometimes can miss things, I don't know that we've received the transcripts that are being referred to by counsel.
Well, that's a different issue. Well, and when and if that arises, because I can't deal with all of these issues in a vacuum in the abstract, right? Some of these are going to have to come up in the moment, and that's fine. What I'm trying to do, which I think is the purpose of motions in limine, is to give the parties some general guidance about what's okay and what's not. And I think that Mr. Carl Patton's existence history and the fact that he was even briefly a suspect, the fact that Ms. Patton was allegedly involved in his murders or in cleanup, whatever, right? Those things are fair game, and I think that to the extent the defense, I think those things are going to be facially relevant and not overly prejudicial. What I am concerned about, though, is confusion of the issues and prejudice that might arise if we go too far into the granular details, absent a clear showing of specific relevance of those details. Into the details of the killings committed by Carl Patton. And so that's my general guidance to you, understanding that as we start asking questions and get into the back and forth of actual witness presentation, you may satisfy me that it's necessary for you to go into the particulars of one or more of the particular killings by Mr. Patton. But right now, in a vacuum, absent a particular showing, a more particularized showing of relevance, I'm saying stay up here at the 50,000 foot level, and let's not get down into the weeds unless and until there's a showing that it's relevant for your purposes in this case.
So just to be clear, what I've already mentioned about the motives, at least in 2 of those killings, to keep people silent who are going to talk about his murders, is that 50,000 foot level, or is that down in granular level, or where are we talking about? Because a general motive for killing somebody, it seems to me, would be directly relevant to this case.
So I think you're asking me to conduct a sort of quasi 404B analysis, right? In terms of, I understand Mr. Carl Patton doesn't have any 404B rights in this trial, but
also that's been specifically talked about in the case law.
I understand.
404 does not enter into the analysis at all.
I understand. I guess my point here is I've given you, I think, what are the general broad strokes, and so beyond that, I think you need to conduct your examinations of your witnesses in the way that you believe is necessary, and I will deal with individual objections as they arise. Again, my point is Mr. Patton's crimes, that they happened, that he was convicted for them, that Ms. Patton was involved in them, I think those are all, we're all expecting those are going to be relevant and discussed in this trial. I'm just trying to avoid getting down into the nitty gritty of it unless it's relevant and necessary for you. And if that's the showing that you're going to try and make, then I may agree with you. I'm just not going to do it right now. Okay? Anything else that we need to take up pre-trial?
Last thing, Your Honor. Good morning.
Good morning.
I know that there may be some witnesses that have criminal histories. I believe some may be older than 10 years. It is my understanding that we have not received any notice from the defense if they're going to try to impeach using convictions older than 10 years. And so I just wanted to bring that issue before the courts. I don't know if they exist or not, or if they plan to, but there needed to be notice if that was going to happen. And so wanted to kind of deal with that before a question comes out on the stand and we haven't addressed it, Your Honor.
Mr. McDermott?
Off the top of my head, I can only think of one that might be in that category. And in 1991, and it's not an impeachment issue. It's another third-party guilt. It's actually to explain one of the reasons Melissa ran away from home. And in 1991, her sister had a baby in their house. I don't know if it's unexpected. Certainly it could have been unexpected, but she did it in secret. She didn't want to keep the baby or something of that nature, and tried to secretly dispose of that baby in a clothes hamper in their house. And we have the court records from that conviction.
What in the depths of this family? Oh, for the love of Bob Ross. This is already like 12 shades of crazy, and we haven't even gotten to opening statements, y'all.
I'll finish the story briefly. Melissa is the one who found that baby, and she didn't know what to do with it. She ends up telling people at school, and then the police come. Long story short, Tina ends up getting convicted for concealing the death of another in 1992. I don't even really need to talk about the conviction aspect of it. I just need to talk about the crime and what happened to Melissa. And, you know, it was shortly after that 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 was the final straw for her. She starts running away from home regularly. So I do want to talk about that incident. If it's going to be an issue with the conviction or whatever, I'm not bringing it in for impeachment purposes.
Okay. So 2 things. One, I agree generally with Mr. McDermott's characterization that everything all the circumstances that led up to whatever conviction occurred might be relevant with particular witnesses or whatever. And the fact of the conviction, it sounds like, is not really his target. Although I agree with the state that if you wanted to talk about that conviction, then I think there are some notice obligations. That's number one. Number 2, though, is setting aside the notice obligations from a substantive perspective. The purpose of the rule prohibiting convictions older than 10 years is because presumably they're stale. They're not particularly compelling or relevant to the veracity of a witness who's testifying now. But if we're talking about events that occurred more than 20 years ago, right, then the fact that they were convicted of something 22 years ago might be more relevant than it normally would if we're talking about a crime that happened last year and somebody wants to try and impeach or bring in evidence of a prior conviction from 10 or 15 years ago. And so that's my only concern. Ms.
And yeah,
Hilton.
understand that, and I guess this particular incident, what I think the state is having an issue with is the relevancy of Ms. Tina Patton having a child and Melissa.
So forgive me, Ms. Hilton, for interrupting you. I'm not ruling that that information is admissible. What I'm saying is that Mr. McDermott is not, to my ear, indicating that he intends to offer evidence of a conviction of that witness, which means there would be no notice obligation, number one. And number two, the issue about the substance of what he wants to offer, that I'm going to have to deal with that when it comes up. I don't know what the relevance is yet because I don't know why he would offer it. He seems to think that he has some facial basis to make a showing of relevance at the appropriate time.
Thank you, Your Honor. I definitely understand the notice requirement, if that's his understanding. My concern now, hearing what he may offer it for once the witness is on the stand, is that we can't unring the bell once he asks whatever question he asks in a moment for me to object. If he asks, did you kill your baby and leave the baby at home, and then I object, that question is already out and for. So if he's going to use, I want to deal with it maybe in a motion and limit that that's not relevant. But I'm not fully understanding all of the facts that he would like to bring in, since I'm just hearing about it now.
Mr. McDermott, why is it that you believe, I assume that you're going to go into, you plan to go into that when Tina Patton is on the stand?
I intend to mention it in opening, actually, Your Honor, because one of the key issues running through this trial is Norma Patton's claim that she had a loving relationship with Melissa. And we're going to put up lots of evidence that that was not the case. That Melissa wanted to come back home and Christopher wouldn't let her. That Melissa kept trying to leave Chris and come back home to them, and it's just simply not true. And we have tons of reasons why. And one of the reasons why that led to her initially starting to run away is the discovery of this baby. And that was the last straw. And I think it's going to be a testament to the abusive and foul relationship she had with the people in that home and her opinion of them. And that's all relevant to why she did not have the relationship that Norma Patton is going to claim on the stand that she did have.
Ms. Hilton?
Interesting.
Your Honor, because Ms. Wolfenbarger isn't here, some of this be speculation on the part of anyone to say this is the reason why she left home. So we don't even have credible, I believe, evidence as to this is going to be the reason why she went home, or one of the many reasons why she went home. So now we're on a fishing expedition to ask questions that are speculative in nature, as well as not relevant in this particular incident as to whether or not Mr. Wolfenbarger killed or murdered his wife. I think we're now going to essentially try to muddy the waters in this trial to put in all of this extraneous evidence, and it's taking away from whether or not Mr. Wolfenbarger killed his wife. And so this particular evidence of a baby being killed in a home, or potentially being killed in a home, and this is the reason why she's running away, is speculation. I don't know who's going to testify to that. So when you start asking those questions, now you are bringing in issues that are confusing the jury without any clear evidence to that, Your Honor. So that is our position as to why the details of this particular incident is not relevant, Your Honor, in this case. It'll be speculative and it's not relevant.
Okay. I agree with you. If the defense tries to argue or to get a witness to say, isn't that why Melissa ran away or whatever, that's argument, right? But if Mr. McDermott can establish facts that created what he's going to argue was a hostile home environment that would not lend itself either to indict the credibility of those witnesses or to demonstrate why Melissa wasn't there, I think that's fair game. But again, I would like to caution that there is a risk here of confusing the jury, of inflaming the jury with things that are extraneous, and we're all going to be very cautious about engaging in that endeavor.
Thank you, Your Honor.
Okay. Anything else?
Nothing, but I just emailed Ms. German for the Zoom link. I did intend on using PowerPoint.
Okay. Ms. Johnson, if you can hear me, or Ms. German, if you could make sure that the lawyers have the Zoom link for today so they can log in. Last thing, Mr. McDermott, anything else you need the court to address pretrial?
No.
Okay.
I'm actually really excited to hear the opening statements now, because again, just the very cursory looking over of that one article didn't put into perspective the sort of other side of the Carl and Norma Pattinson, or no, I don't know why I want to say Pattinson, Patton dynamic. And if this had a greater impact on, Melissa's disappearance, I do, want to see what the defense is going to put up, what the state is going to put up. I really have no clue as to what I feel about this case right now. Obviously, the state had enough evidence to get a grand jury to indict, but we'll have to see what kind of case they come up with, because this is in Fulton County, and Fulton County has been rife with, well, basically state prosecutors' inability to get discovery and on time and to conduct a large profile case, a la, or i.e. the, YSL trial. So this is going to be interesting to see if Fulton County can redeem themselves and what the defense has to say.
Okay, so the last thing that I needed to take up, I do have all of my jurors. I did want to let you know that juror number, no, not that one, the dialysis. 43, who y'all will recall is the gentleman that that told us that he was on home dialysis. He has presented today, he is here, but he has also sent to my office a letter from a physician at Dialysis Care Center asking for that individual to be excused because he has a diagnosis of end-stage renal disease. My understanding is, I think the numbers indicate that he is an alternate, but he is here. I think there was a discussion on the record when we were talking about whether or not to excuse that juror for hardship that I think I and the lawyers asked him any number of questions about whether he could make it work. And it seems like maybe he doesn't think he can, but he didn't say that clearly during the process of voir dire. What are our thoughts on what to do with that? Now, I feel like if he's here, I need to inquire, is he asking to be excused, right? Because this letter, since he didn't say that, number one. Number two is, if it's a matter of accommodating him from a time perspective, right, I can say, hey, well, I'll guarantee you we'll be out of here every day at 5 o'clock, or whatever I might need to do to enable him to conduct his home dialysis timely. What are your thoughts, gentlemen?
I would agree with that, yeah.
I agree.
Okay. With your permission, I'm going to have, rather than bring him out here to ask that question, I'm going to have my staff ask, are you aware we received this letter? Because this letter was faxed directly to us from the healthcare provider.
I was not aware.
I'm sorry?
No, go ahead, Thomas.
And I'm going to have Ms. Sherman ask him, are you asking to be excused? So that I can then make that clear to y'all, and then y'all can make a decision about whether we wish to excuse him or not. Everybody good with that, Mr. Fossett?
Yes, it's on the defense is.
Mr. McDermott?
I'm good with that.
Okay. Mr. Sherman, come here, please.
Oh my. We may get to opening statements at one point. We really might.
Okay.
So if we excuse him, are we considering getting another alternate? Or we haven't got to that stage yet?
Well, he is an alternate, so I mean, we would just proceed with only one alternate.
That was the question.
Yes, sir.
Proceed with one or go ahead and try to find another?
That's y'all's decision. I'll do whichever you ask. Logistically, seating another alternate at this point and getting them here from whatever corner of the county they reside in might mean that we're starting opening statements at 1 or 2 o'clock instead of at 11.
But that might be something that the defense wants to do if they've already burned up an alternate because of this.
I'm told that he seems quite comfortable back there. That was one of the reasons I wanted to ask if we can accommodate you to make it easier. Are you asking to be excused, or did you just want us to be aware of this medical information? So I don't know that y'all can think about what your options might be if he says he wishes to be excused, but I don't know that we have to solve that problem just now because he might say he's fine. He'll take it day by day.
Howdy. We have been through a good bit of kind of the housekeeping, pre-trial. Hey, does anyone have anything that we need to get into? A good 5 pages worth of notes on that. And now we're trying to figure out if the gentleman on home dialysis who insisted he was going to be okay with jury duty is still okay with jury duty. This case is wild, and it isn't, we haven't even gotten to open statements yet. I will
Not on the
say,
record. The Zoom link that you
I will say that the judge and the lawyers seem to all be able and not phobic of microphones. So this might be a miraculous trial in the audio sense, but it is foobar, and we haven't even gotten to opening statements. Okay. We are just going to, all right. Let's see if we get a,
wire with juror number 43, whether or not he was asking to be excused, or whether, you know, what the purpose of providing us with that information was. And he has communicated to her that he wanted us to be aware of the nature of it, that he reached out to his doctor, but that he's actually not asking to be excused. And so he has stayed and elected to remain. We did advise him that we would try to accommodate him to the extent necessary. And he mentioned a couple of things that we'll need to work with schedule, but nothing that I've seen that's too burdensome in terms of, you know, ending one day at about 3:30 or something like that. So, but that's, we're going to go from there. So 43 stays. I just wanted you to be aware that I had that information from his doctor. Anything to put on the record regarding that matter, Mr. Fawcett, from the state?
Not from the state, Judge.
Mr. McDermott?
Nothing from the defense.
Okay. So are we ready to get started? State ready?
Yes, I'm going to share my screen now. With the
Okay.
commission.
And have the parties had a chance to make sure that there's not anything significantly objectionable that, I mean, like, have you shown each other? I don't want
I did show counsel, but I
Okay.
intended to show in the opening statement. I did not hear an objection.
to, Mr. McDermott?
I don't believe I got your full PowerPoint presentation, did I?
I didn't send it to you, but
So I have not been able to look at that, right?
well, I showed you the photo.
Well, let me say this. Excuse me, gentlemen, I'm going to be talking to the jury for about the next 25 minutes, so I think you'll have time to look at it, and then you can let me know if there's an issue. Okay?
Oh, that was-
all right. We are going to skip through the juror's instruction. Typically at the start of a trial, basically the judge is going to go through and explain what the crime is, what the laws are, and kind of how they're supposed to be acting as a juror. Now, considering it took us nearly an hour and 20 minutes to just get to opening statements, and this is the Petty Express, and I'm the judge and jury on the Petty Express, I'm skipping that. But we are going to start with the opening statements from the state. And hopefully this will shed some more light on a complex story.
This is the State of Georgia versus Christopher Wolfenbarger. It's been 27 years since 1998. And specifically, December of 1998. That was the last time that Melissa Wolfenbarger was ever heard from. At that point, in 1998, Melissa Wolfenbarger was 21 years of age. She was married, had 2 children, a mother, sister, and after 1998, in December, neither one of them ever received a phone call, not a visit, not a card. Not after Christmas of 1998. Not after her mother's birthday in 1999 in February. So you're going to hear that Melissa, at the age of 21, she had experiences when she was a child when she would run away from home. She had experiences during her adulthood after she married this defendant, Christopher Wolfenbarger, when she would not talk to her sister for a period of time. But she would always keep in touch with her mother. Most importantly, She never let a holiday go by without calling or visiting. In November of 1998, Melissa had the intent to visit her mother for Thanksgiving. They spoke. One of the things that Melissa was really looking forward to was getting a photograph of her pawpaw, her grandfather, the father of Carl Patton, Melissa's grandfather, and that is Carl Patton, Melissa's father, and that is the husband of Norma Patton. She wanted that photo, and Norma Patton expected that at some point between Thanksgiving, even though she didn't get an opportunity to go visit her mom, that she would get that photograph. Well, when Christmas came around, she was concerned that she didn't care for it. But by the time she got to February, she knew something was wrong. Melissa never will let that much time go without talking to her mom, not especially during that period of time, not on her birthday. Well, it took some time for authorities to be alerted, because you're going to hear that Melissa wasn't reported missing until January of 2000. And that was because this defendant, Christopher Wolfenbarger, you're going to hear from his own words. You're going to hear what he told the detectives, what he told his children. He never looked for her. He never reported her missing. So when Norma Patton and Tina Patton are looking for Melissa, where is she? She's not working anymore. She works at Waffle House. She's not showing up to her job. She's not looking after her children. She's not checking on her children. No word. Well, the authorities tell them that, well, Melissa is 21. She's married. She's got her own life. She hasn't called you, then maybe she doesn't want to talk to you. Her husband hasn't reported her missing. And you had to talk to her mom. Well, not really much for us to do right now. But eventually, Melissa's mother goes to Henry County, and they start an investigation. But even though they talked to friends and family, they even talked to Christopher. And all we get from him is she just left. That's it. That goes on for 3 years. She gets unidentified for 3 years. And that takes us to really when we locate the remains of Melissa Wolfenbarger. They were located on 2 different days. April 29th and June 3rd of 1999. Now, April 29th, George McKeitry is driving on the area, heard questions about Avon Avenue. That location is the location of Action Glass Company. You're going to hear that is the location where Christopher Wolfenbarger works. The glass company has a manufacturing plant. They have industrial equipment at this location. That's where he works. Although they had no reason to think that was anything significant at the time, because in April 29th of 1999, all they knew was that there was a head in the roadway, partially, fully, very much fully decomposed. And Mr. McKeitry, George McKeitry, is driving in that area on Avon Avenue, and he sees something that he thinks is kind of odd. So he stops and looks at it, goes and gets his daughter, and comes back, and he can see what clearly is a human head. Now, something that he would tell you he couldn't believe with his own eyes what he couldn't believe. Well, that begins the discovery and really the process of trying to identify that skull. That's those same detectives, the lead detective at that time, Dale Kelly. You're going to hear from the Fulton County Medical Examiners, investigators, Tia Miller. They were all out there at the location on Avon Avenue, April 29, 1999, collecting evidence, taking photographs, some of which you could see. Ultimately, they start looking for information on who this could belong to. Then you find the extremities on June 3rd, 1999. That these extremities are found, everything but the torso, or everything but the midsection of the Melissa Wolfenbarger is located. Femur, and you'll hear from the detectives, you'll hear from the medical examiners. When the skull was found, it had a portion of the spine attached to the skull, and it appeared as though it had been severed or removed with some type of circular saw. The extremities were examined. Detectives, medical examiners, the anthropologist who worked for Polk County Medical Examiner's Office, they observed signs of tooth marks. The anthropologist describes the different lines on the bones as what happens when a saw is attempting to catch a groove and actually cut. You see the bones where there's the saw marks on the finger of the Wolfenbarger. You will see the end of the finger where it appears as though you see ridges on the bone where that saw was cut. But even on June 3rd of 1999, they didn't even have these cases connected. They were found about 50, 60 feet from each other in that same area. They didn't have a basis to connect to, so they were in the medical examiner's office as two separate case files. Skull found on A1 Avenue. And extremities found almost 2 months later on A1 Avenue. It's expected that the cases may be connected, but they didn't have what you needed to actually combine and connect the cases and say that they were the same person. But what do you do at the beginning of a homicide investigation? The first thing that law enforcement does, especially when there's evidence of foul play, as in this case, when you find out who the victim is, who the person is, you go look at the background. And what did they find when they looked at what Melissa's life was like when she was alive in 97, 98? Who was she talking with? Did she have conflict with anyone? Is she married? What was her marriage like? Were there instances of abuse in the marriage? Had her husband ever been charged with anything related to that abuse, like hitting her? They looked at that information, and I'll tell you that at the time they did find the identity and were able to determine the identity of skull and extremities, Christopher Wolfenbarger was the primary suspect. I'll just tell you that. He was the main person that they were looking at. He wasn't the only person, because you got to conduct a thorough sifting investigation, but they had evidence that Christopher and Melissa were involved in a multiple relationship, that Christopher was abusive, that he had struck her on multiple occasions. They had evidence that he had caused a black eye, that she had witnesses that observed bruises on her neck. They had evidence that at some point Melissa applied for a protective order to prevent contact with this offender. You're also going to hear that on the day that Christopher was ordered to come to court, March 29th, ordered to come to court on July 29th of 1998. You're going to see that same day, Melissa appeared and requested for that case to be dismissed. Roughly 70 days after she was hit, 7 days after she went personally and applied for a protective order, 7 days after that, she goes back down to the courthouse and asks for it to be dismissed. I'm going to prosecute her. You're going to hear from a lot of witnesses in this case. You're also going to hear from the domestic violence expert. And that domestic violence expert will be able to explain that that is not uncommon at all. The victims of domestic violence to come back and say, I want to prosecute. You're going to hear about some of the reasons why that can happen. And that was the 21st of July, 1998. Officer Marlon Sutton responded to the residence at 824 Brookline Street in Atlanta. That was the marital residence of Christopher and Melissa Wolfenbarger, the family home of the Wolfenbarger family that Christopher and Melissa were staying in at the time. When Marlon Sutton arrived at that location, it was a response to a domestic violence incident. And when he arrived, he had an opportunity to view Melissa Wolfenbarger and see her in person. What he observed was someone that had bruises, someone that had been attacked, someone that was hysterical and afraid. He didn't see Christopher there that day, though. He wasn't there, he left. So she was instructed to do as she did. You don't feel safe, go and apply for a protective order, which is what she did very much. You want to see those documents, you got them. The day after this, she goes down and files By the time this case comes up, on March 1999, you'll see this document, particular state court documents, actually filing the formal charge of battery against this defendant, 1998. By the time it comes to the court, they can't find Melissa. Can't find her in March 1999. No way of knowing a month and a half later, her head was found in front of his job. Now I'm going to say this too. Less than a minute drive from his house in walking distance. You have this decomposing head, between the knife in front of the job at Avon Avenue. And you got the location of Avon Avenue itself. So this is the Action Glass Company location right here.
Okay.
This is where Christopher Wolfenbarger worked. You'll see this map, and witnesses will explain. Witnesses that were at this location in April of '99 when her head was located. You'll see on the photographs there will be a sewer here, and you'll see where her head is located here. Within about 120 feet from his job. And then in June, you'll see where the extremities, the sawed-off legs of Melissa Wolfenbarger are found in this area. The detectives will tell you when they examined the location, it appeared as though they saw an animal carrying a bag right where the head was located, from this area out onto Avon Avenue. So when they were able to make the connection, they come back with cadaver dogs, and they go back and look in this area, and that's how they find the extremities. That's how they find the June 3rd, 1999 legs, remaining parts of the found. You never find a torso, the remaining parts of the found in the spot. It'll give you a perspective of where his job is.
Okay, wait, that doesn't make any sense. So, in theory, I mean, unless you're a complete sadist, you are dismembering the body to avoid detection. Why would you put the most detectable parts, i.e., your fingers with prints and your hands, and your head and the head, right next to the work, when those are the most identifiable pieces, unless the torso was also disturbed by animal predation, but you think you would still find bones? I don't know. These are the kind of questions I have.
Where Brookline Street is, this is Action Glass. This is the junkyard where the extremities were found. Here is the location of the sewer where the head was found. And less than a minute drive is Brookline Street where Melissa and Christopher Wolfenbarger reside. Now, in 1999, you don't have the Atlanta Beltline. You don't have these buildings. This area is primarily wooded. But that is the location in the proximity of Christopher Wolfenbarger's job, to where his wife's head was found, where his wife's legs were found, and where they lived. This is a case about domestic violence. In addition to the evidence of the physical bruises on the person of Melissa Wolfenbarger, you're going to hear from her family. Her mother knew about the July 1998 attack. Melissa told her about it. She told her mother how Christopher was upset, wanted her to come back, and how he struck her in the face, how he grabbed her and dragged her by the hair. That's why he was arrested. Her mother was one of the persons that she told about that July incident. You're also going to hear from her sister, Tina Patton, who occasionally works. Well, one time in particular in 1998, it was a 2 or 3 month period where Tina Patton, Melissa's sister, worked at a Waffle House. I believe it was Virginia Avenue Waffle House. They worked at a few Waffle Houses that year, Melissa didn't take her. But during that period, in the early part of 1998, Melissa and Tina Patton worked at the Waffle House. And she would tell you that there was one day that she observed, while she was working with Melissa during that period, she observed marks on the neck of Melissa, around the sides, and she knew immediately it looked, and she'll tell you this, it looked like someone had choked Melissa. And Melissa told her that, hey, this is the Waffle House. And You're gonna hear from a man that Melissa was seeing right when she died. You're gonna hear that Melissa planned on leaving his defendant. You're gonna hear from his own mouth that they weren't on good terms when she left, when she went missing. Thomas Dixon was also working at a Waffle House when he met Melissa Wolfenbarger. And towards the end of 1998, they started seeing each other. And at one point, Melissa was staying in a lodge or hotel with Thomas Dixon. And he'll tell you that he was fully aware that she was with this defendant, Christopher Wolfenbarger, but he'll tell you that she wanted to leave. And during that week, she was spending with him. She really planned on doing that, but decided to go back to him, to Christopher in particular, to see her children. She missed them. And Thomas Dixon will tell you that the last time he saw Melissa Wolfenbarger, Christopher Wolfenbarger came up to that Waffle House. Melissa and Christopher had a talk.
For the love of all that is holy, closed caption. Look, it's Wolfenbarger. The closed caption has come up with about 73 different things that their last name is. And you would think with Waffle House, it would be easy to get the closed caption, but no.
And Melissa got hysterical. She started crying. Thomas Dixon will tell you that he went outside to go talk to Christopher and told him that he has to leave until 9 o'clock when she gets off. You're going to hear Thomas Dixon tell you that when Christopher left, he peeled out in his Volkswagen, and that was the last time he saw us. He'll tell you that she never came back to work at Waffle House. She never called, she never texted. And that is the evidence to show that that's consistent with what you'll hear from her mother and sister regarding the last time anyone ever saw her. And as I said, she goes unidentified for 3 years. During this period, the medical examiner that is working in Fulton County is also working in Twiggs County, and is first attempting to determine if a headless corpse that they located in Twiggs County could potentially be connected with this skull they find in Avon Road in Atlanta. That was one thing they were looking into. There were several missing persons in and around the state of Georgia that they were attempting to get dental records for and compare. There were tooth extractions that were done during this period, but all in attempts to find the identity of the person who that skull belonged to. There were attempts to conduct reconstruction. And what further confused it is the anthropologist plots skull dimensions on a scale, and you get a range. And sometimes those ranges overlap. So at some point, they'll tell you that her skull looked like it had been run over, damaged, and she, at some point, the anthropologist thought she considered the skull was male. All this was going on during this period from 1999, April, when they located the skull, June, when they located the extremities. All this is happening during this period, trying to find out who these remains belong to. And ultimately, Melissa doesn't get identified until 2003. And what triggered the identification ultimately is the arrest of Melissa Wolfenbarger's father. You're going to hear that Melissa Wolfenbarger's father essentially pled guilty to committing murder himself, made multiple murders himself.
Have a great lunch,
and when
Wolfram.
he was arrested, it was a notorious publication, it was a notorious arrest. It garnered a lot of attention. You're going to hear that Carl Patton asked the lead detective when he was arrested after he confessed. He asked the detective told him that his daughter was missing for 3 years. He had no leads. He asked if he could find his daughter. Well, at the Fulton County Medical Examiner's Office, we had this unidentified skull they found 3 years ago. And with Carl Patton's statement, they obtained the dental records from Melissa Wolfenbarger's dentist, William Grant. Now, pediatric practice in the 80s and 90s, they obtained his Melissa's original records, x-rays, and they gave Dr. Mary Popley, from the dentist, medical examiner's office, conducted an examination, looked at the x-rays, looked at the fillings, looked at the dimensions of the teeth, and was able to make a conclusive determination that the skull that was found in April 1999 was in fact the the skull that belongs to Miss Wolfenbarger, but no records match the impressions that she took from the skull.
I hadn't heard that they could use pediatric dental records to match with your adult dental records. Now, again, as not a dentist, maybe it's possible that you can do that, but this is the first time that I've heard that they took actual, pediatric dental records and were able to match a skull, of an adult person.
It's matched. That's when all the location of the job, that's when all the location of the house, the location of the extremities, and the skull between the job, that's when all that comes in. And that's already a suspect. That's when they're really focusing on this. You know what he says? Same thing. She just left. Then he says, oh, well, I dropped off at the train station. You're going to hear those statements from him. And you're going to hear the detective's questioning him about those statements and that explanation. As I said, the skull is identified by an apostle. There were 2 medical examiners during that period. In 1998, we first started in 1999, we first started their examinations. Dr. Carol Terry and Dr. Joseph Parker. Dr. Joseph Parker is no longer living, but you will hear from Dr. Carol Terry, who will tell you that she examined the extremities. She'll tell you that she examined the skull and that they appeared to have evidence of 2 marks. And she'll tell you that her expert opinion is that Melissa Wolfenbarger is murdered. The circumstances of her lifestyle, how she was living, what's happening to her, the circumstances of her remains, the condition that they were found in, was entirely likely she was murdered. That's what she'll tell you. Tina Patton is the sister of Mrs. Wolfenbarger that you hear from at some point today. Melissa told her that Chris was responsible for the bruises on her neck. You'll hear from Norma Patton, Melissa's mother. She was told about the battery in July of '98. Melissa told her mother that she wanted to leave this defendant. She told her that he was abusive. And here's Thomas Dixon, who was with him. Probably one of the last persons that Melissa saw. He also has information he's going to tell you about how abusive this defendant was when Melissa's on out. And you're going to hear from Christina Garrett. Christina Garrett is the daughter of Melissa Wolfenbarger and Christopher Wolfenbarger. And the one thing she'll tell you is that she recalls her mother. The one thing that kind of stood out is she just remembers her mother kind of disappearing one day.
And at the bottom of all of this crazy, potential, sensational father of the victim being a multiple murderer and possibly the mom, being his, Bonnie to his Clyde. At the bottom of this are 2 little girls who, one day lost their mom. And as much as this case has already cooked me with the crazy, I hope that at the end of this, those girls get some answers or, at least some sort of answer in this case.
To tell you that one of the odd things that she cannot reconcile is almost immediately after Melissa just vanished, this defendant essentially just removes all of her stuff out of the house. You can see a picture of mother, the belongings, things of that nature. It's gone. While she was growing up, she would constantly ask him, "Where's my mother?" And you would expect that you would have heard an answer at some point. Sometimes that's where she would tell you that he never answered her question. He never told her how to look for her. He never told her how to report her missing. Nothing. In fact, she would tell you that this defendant would tell her while he was growing up that he knows how to get rid of a body. He knows how to not get caught. He also told his daughter, and you will hear this from her mouth, that he had a place to go on the run if he needed to. Now, Christina Wolfenbarger, grew up in basically being cared for by Kathy Wolfenbarger, Christopher Wolfenbarger's biological mother. She lived in the house until she was able to leave when she became an adult. You're going to hear that when she left the house, grandmother, and she was able to get out on her own, that's when law enforcement gets that information for her, around 2015, 2016. that information about what he told her while she was doing it. You're gonna hear from Dorothy Jones. Now, Dorothy Jones is a resident of that neighborhood at that around the 800 Brookline Road area, close to the Action Glass Company where Christopher Wolfenbarger worked, close to the location where Melissa Wolfenbarger's skull was located, close to the location where Melissa Wolfenbarger's remains were located. Dorothy Jones is familiar with that location, and since what she's going to tell you is she pretty much hung out with Christopher pretty much every day during that period. She remembers it. She remembers Melissa. She remembers seeing signs of Melissa being abused. She would tell you that she saw Melissa with a black eye herself. That she would punch her eye. She's also going to tell you that she's heard them fighting at that house last week. Probably the most disturbing thing she's going to tell you is that she saw him every day for about a 10-year period. And just one day, Melissa was gone, never saw her again, and Chris was gone. And she says, not only gone, but just kind of left all the stuff. It's in there. You're going to hear about the signs of trauma. There will be some photographs that you'll see solely for the purpose of illustrating the tool marks, the mechanical device that was used to disconnect the limbs of Melissa Wolfenbarger. And most importantly, you'll hear this defendant's own statement. During that 1999 period, he told the officers that he was fired because the owners thought he stole a saw. He admits to borrowing it. He admits to using it to cut the top off his car. He never got the saw back.
Wait, to cut the top off of his car? He stole a saw to cut the top off his car. All right, you know what? Jesus, take the wheel. This case is already crazy. I didn't have that on my bingo card, but apparently saw, removal of car top, as you do.
And you'll hear from the anthropologists, the detectives, the medical examiner, that there are signs that Melissa Wolfenbarger's remains have been solved.
Sawed, not solved.
Also hear about the day he was arrested, in 2024. And it did not go like a typical execution of a warrant for homicide, because it took quite a bit of time to locate this offender. In fact, they didn't locate him in the residence portion of the house. They located him inside area, so it was the garage that was situated in the living space. They found him in a something that looks better to show it has an appearance that it was created for the purpose of the crime. That's what the evidence is going to show. After about 40 to 50 minutes, they get the dogs, and you just can't hide from the dogs, right? The dogs hit, come on out of there. You see, that's what you're going to get. When he crawls out of there, after an hour, and evidence is going to show he knew exactly who was at his front door. It will be your determination, your decision as to why. Possibly you. It will be clear why. It will be clear. They were there to find, arrest this defendant for the murder of his wife. Arrest this defendant for dismembering his wife. They were there to arrest him for holding him accountable for taking Melissa Wolfenbarger from other and sisters who supported her children. At the conclusion of this case, the evidence, testimony, the exhibits, you will be left with one decision, and that's to vote the truth. And I submit to you, the truth will be guilty. Both counts of the state indicted for the murder of Melissa Wolfenbarger.
Thank you. Mr. McDermott, does the defense wish to make an opening statement?
Yes, ma'am.
Okay, you may proceed.
Okay.
We can all agree that Melissa Wolfenbarger did suffer a tragic death. And you haven't yet heard the extent of which she had suffered a tragic life. But the extent of her suffering in life and in death had nothing to do with Christopher Wolfenbarger. The state's story begins correctly. This is a case about a horrifying discovery of human remains that later became identified as Melissa Wolfenbarger's. But the evidence will show you over the next few days that the state's story has gaping holes in it. And that the state is going to ask you effectively to imagine in order to connect the dots between those over those gaping holes. To fill the gaps, if you will. What the state is inclined.
Tanya Mackey, caffeine, nicotine, murder case trial, and Mo in the deep end. I've missed my mornings with Mo. Well, I'm glad you're here. I will tell you, you probably need to go back to the start of this. This case, we've just barely got through opening statements, and I've already got like 19 pages of notes. To be fair, it is a small notebook. That being said, what in the Fazoli's / Waffle House at 3 a.m. am I watching? Let's continue. Now, basically, the too long didn't read is that Melissa is a young woman who disappeared from all traces from her family, her husband, her children, and her, mom, dad, sister in 1998. Around 1999, there were random remains found in two separate time periods. A head at first that was pretty much completely decomposed, and then limbs. No torso has ever been found in this case. Now, there wasn't even enough to link the head to the limbs. So Emmy was continuing to try to identify these remains. However, it would take until 2003, where the victim's father, Carl Patton, was convicted on, I believe, 5 murders in a fairly famous Georgia case called the Flint Hill cases, or Flint Valley. Let me double check that because it would be wrong. One second. Yes, the Flint River murders. So these were murders very prominent in the 70s. Melissa Wolfenbarger's father, Carl, was later convicted of those. He basically asked detectives to find his daughter, who wasn't able to be found. And then they did tests of the remains against both his wife Norma's DNA, but also dental records. So Melissa was identified. And now the state has basically accused Christopher Wolfenbarger of being the one who ended Melissa's life. The disparate body parts were found within, walking distance, 120 feet from where he used to work at the time when Melissa disappeared. There are allegations of, DV in Christopher and Melissa's relationship. The state says that they're going to bring witnesses, and Melissa had filed for a protective order that she 7 days later did dismiss. So unfortunately, that didn't seem to help her. But there have been allegations made against Chris, and for most of this, Melissa being missing, Chris has been a suspect. Now, the defense is coming up to give their opening statement. You will find that they're going to be focusing, I think, a lot on third-party culprit. And you do have a ready-made, third party with, a father who is, prone to engage in red rum, and his daughter passing away. I'm sure the state is going to have to go through, or had to go through, some investigative work to get the father out of issues, or get him to where he had an alibi or he couldn't be responsible for his daughter's case. I know literally nothing. I looked this case up about 4 a.m. this morning and did a short video to try of an article I found that was a bit more comprehensive than what I've tried to explain to you, but this is a crazy case. So let's get into it. Now they're currently on day 4. We are going at a fairly okay clip on day 1, considering all the crazy, but let's keep going. We're going to just chug along because this case is crazy.
To tell you in this case is far more important than what they have told you. And your job over the next few days is going to be to see those gaps, to refuse to imagine, and to demand proof of all the elements of the crime that's charged beyond a reasonable doubt. You're going to hear evidence, some of it from their own witnesses, that multiple other individuals could have had something to do with Melissa's death, starting with her own parents. You've heard mention already of the Flint River murders. Melissa's father, Carl Patton, committed a string of murders in the late 1970s. He was suspected of those murders for a long time. He was investigated, but they were not prosecuted and proved until 2003, 4 years after Melissa's disappearance and death. You'll be presented with evidence that Norma Patton, his wife, helped him directly commit at least 2 of those murders, to dispose of the bodies, to clean up the crime scenes, and to wrap up the bodies and dispose of them in ways that are somewhat similar to the way Melissa's remains were found. Carl, Melissa's father, died in prison last December. Melissa's father eventually confessed to killing 5 people. Some of those were for personal revenge, some of those were contract killings for money, and at least 2 of those were murders of his own friends because they knew too much. All of the victims were either close friends or family members. In one case, Carl knew how to stage a crime scene. He turned what was a shooting to look like an accident of a car on train tracks.
Your Honor, I object to the defense's content of their opening statement. The statements made by counsel are just simply irrelevant to any issues that are presented during this trial.
As previously discussed, they're going to be relevant.
Okay, I mean, as a curious kitten over here, I kind of want to know how he made, a red rum look like a train accident. Although I think the finesse of a train, running you over might negate any other, signs of criminology that happen to you. So, when a blunt tool is needed, perhaps a train wreck is required. What is this case? Did I take a bunch of gummies I didn't know about? We have now talked about contract, red rums and freaking dialysis on the daily. What is going on here?
I'm going to overrule the objection on relevance grounds. I am, however, going to request that you, in line with our earlier discussion pre-trial, limit some of the details unless and until that evidence is presented to the jury.
I will not get into any more granular detail than I have so far.
Thank you.
Satisfactory?
Yes, sir.
Melissa's mother in 2 of those murders was a co-defendant. She confessed to planning 2 cold-blooded murders, cleaning up the blood, bleaching the floor, etc. And the murders from which the name that comes to those murders is the Flint River murders is because one of those bodies was dumped in the Flint River, the other in the Altamont River. And the only reason Norma didn't go to prison like Carl did was because she got immunity to testify against him. And she'll be here to testify this week. The evidence will show that there is also a Patton family associate who also had very strong motives to kill Melissa. We're trying to get him prosecuted for allegedly molesting her in the 90s, and also because his father later turned out, to his knowledge, was one of Carl's victims. And until he learned that, he was a family friend and hung out with the family. And that man's name is Eric Martin Jackson. You'll find out later that at some point Martin learned what Melissa's father had done to his father. And he goes and buys a series of burial plots at a cemetery in 1997, a year before Melissa goes missing, or maybe a year and a half. And he buys them in the very cemetery that Melissa is buried in today. And later, because later he sold those plots to her family. And there are others I'll touch on in just a minute. We expect Norma Patton to come here and testify that she had a loving relationship with Melissa, that Melissa loved her, communicated with her, stayed in touch with her, tried to get away from Christopher's control every chance she could get, so she could come back to Norma's home and see her. But the evidence is going to show that Melissa was actually abused by her mother in her own home for many years and started running away frequently. Her mother locked her in a room all day, every day, from roughly ages 7 to 12. The evidence will show that their home was so foul and dirty that Melissa acquired a foul smell in her clothes and hair that made the other kids at school bully her and tease her. You'll hear evidence from Melissa's next-door neighbor and childhood friend that she will detail the abuse that she endured in that house. Moreover, at some point before Melissa ran away, her sister Tina had a pregnancy in that house, delivered the baby in the house secretly, and tried to dispose of it secretly in a clothes hamper in the house. 13-year-old Melissa discovered that baby's corpse. She eventually told school officials, who later called police, and it was at that point that Melissa began running away from her home regularly. Christopher, in fact, first met Melissa because she ran away from home. And through a mutual friend, they met at that mutual friend's house. Now, Christopher and Melissa eventually got married, and they did so fairly hurriedly. They were both 17 when they got married. They had 2 children very young, in very close succession. When Melissa was still pregnant with her second child in 1996, she went to Christopher's mother, Kathy Wolfenbarger, who will testify, that Melissa asked her if she would take custody of their children temporarily. And she did. When Melissa got in some legal trouble the next year in Gwinnett County and went on probation for theft, it was after that they began to, that's when they moved up to Brookline in July of '98. Their children lived with Christopher's mother in Stockbridge and later in Locust Grove, Georgia. When Christopher and Melissa moved up to Brookline in 1998, the children did not go with them. Now, you've heard some talk about an incident that happened in July of 1998 when Melissa took out charges against Christopher. You also heard the state tell you that Melissa came back and dropped the request for that protective order. What they didn't tell you is the very next day, Melissa calls Kathy Wolfenbarger from the Henry County Superior Court and asks her to please come down and sign the papers to make her custody of those children permanent. To make Kathy's custody of Melissa's children permanent. And Melissa permanently relinquishes her parental rights to those children. One of the reasons Melissa originally gave for giving her children over to Kathy Wolfenbarger, and she tells this to Kathy, and she tells this also to Christopher's sister independently, was that she did not want her parents to have anything to do with her children because they are bad people. After relinquishing her parental rights, Melissa quit working around that time at the Waffle House in East Point with her sister, and for some reason begins randomly working at a Waffle House clear up in Doraville. No one knows why she went up there. But according to everyone, no one had any connections up there, friends or family or anything. But she goes up there and starts working. Melissa started spending more and more time in Doraville, days at a time, working double shifts, spending the night at someone's house, and then multiple days, and days turned into weeks, she would be gone from Christopher's house. And it was at that time that she had started seeing Thomas Michael Dixon, the state mentioned a while ago. We'll have a chance to cross-examine him. In October of that year, Melissa got arrested in Gwinnett County for violating her probation, and she spent 30 days in jail until early November. The terms of her probation required her to do community service. This was outstanding for 1997 still. In fact, she was to do community service, she was to take GED classes, and she was to report regularly to her probation officer, and she had not done any of that. And so they arrested her, gave her 30 days in jail, and then released her back on the same terms of probation. Within 1 month, she is already violating her probation again, although she was not rearrested at that time. So at this point in her life, Melissa was spending as much, if not more, time in Doraville as she was at Christopher's house. She only occasionally came back to see Christopher. She had her own job. She had her own money. She had her own circle of friends. She had her own freedom. She had no obligations to her children. And so when in December of 1998, she did not come home for several weeks or months, Christopher could safely assume she had decided to live her own life on her own terms.
I will say that this is a bad fact that the defense is really stepping ahead of. Now, again, they have to show evidence of this and they have to, cross-examine all these witnesses and bring forth this, reasonable doubt. But as a person, that's just taking this on a theory, or if she did have this sort of chaotic kind of living pattern, uh, you know, well, fair point. Uh, it is a good thing to put out there that at this point he would not have a motivation. Now, because I didn't really follow the case prior to this, and it will have to be verified by the state, I was unaware that Melissa had relinquished her parental rights, because it does seem much more suspicious if you go under the premise that he is at home with two younger children and his wife doesn't show up for weeks and days and he doesn't tell anyone. But if she had already relinquished custody of her children, and I'm sure there'll be documentation that the defense or the state is going to bring forward, then it doesn't, raise as much of a red flag to me if they were leading essentially separate lives, that he wouldn't, say anything about her being missing. Now, again, I'm kind of taking this on a blank slate of, if I were a juror, would this make sense to me? Absence of all evidence right now, because we're still only in opening statements. But this is, I think, a good example of getting ahead of bad facts or explaining bad facts before the other side can take a hold of them. I mean, he has to explain why Christopher, other than for he done it, why he wouldn't have been really motivated to find his wife, because that's out of the realm of normality to a lot of us. It sounds like that sadly, Melissa, even if it's simply the, violent partner, it seems like she experienced a lot of chaos in her life. And it's really quite sad. But this is something that the defense is going to need to do in order to, try to put a third party culprit out there. I'm really interested now as we've kind of seen the lay of the land a little bit more. I think one of the big witnesses for me is going to be Norma, and seeing how I feel and get a read on her and her answers and how they line up, because the defense is bringing up a lot of, rather, well, fair points, like, hey, I mean, this kind of makes sense. Her parents were multiple red rummers. This could possibly be something that they wouldn't be discomforted by. And from what the defense is telling us, the chaotic, childhood, it sounds just like a whole lot of a very, very sad, very short life. And hopefully by the end of the trial, we get more answers, because I don't want to have to deep dive into this myself.
Wherever she decided to live. Moreover, if Christopher had raised a stink about it at the time, Melissa was in violation of her probation. She would have been arrested. Melissa's mother, Norma, is expected to testify variously, as you've already heard, that when she didn't hear from Melissa at Christmas in 1998, that's when she knew something was wrong. Alternatively, however, she will testify that no, it was not until my birthday rolled around. That's when I knew something was wrong. She will tell multiple versions of this story. In one version of the story, well, let me back up. The evidence will show you that in multiple versions of the story, whichever version she tells, she never reports Melissa missing until 2000, January of 2000. If something was wrong in December of 98, something was wrong in February of 99 on her birthday, something is wrong a month later, a month later, a month later, her mother doesn't report it. She doesn't file a missing persons report until 2000. The human remains in this case, as you heard, were found on Avon Avenue. It's an industrial area near the west end of Atlanta. The evidence will show that it just so happens Melissa's father, Carl Patton, was familiar with this area. He grew up in a childhood home on Main Street in College Park. It's just a few miles down the road. Further, the evidence will show that Norma and Carl actually went up to Brookline Street right after her birthday in February of 1999. They found Christopher's empty house at that time. They learned from a neighbor that Christopher had moved out sometime between Christmas and New Year's. They also learned that from that neighbor that Christopher worked at Action Glass down on Avon Avenue. So they drove down to Avon Avenue and talked to the people at Action Glass. And they learned that he had been let go there. Again, this is February 1999. Carl and Norma Patton knew where Chris worked and where he lived months before the head was found on Avon Avenue, right beside where he worked. The state is correct that Melissa's mother and sister are going to testify against Christopher. They're going to blame him. They're going to call him a domestic abuser. But there's a lot of context you don't know. Keep in mind, as we've already said, the evidence is going to show that Melissa only met Christopher when she ran away from home. The evidence is also going to show you that Norma Patton has consistently, out of her own mouth, stated that she absolutely hates Christopher. From the very first time she ever saw him, she hated him. She worked and did everything in her power possible to prevent Christopher from seeing Melissa. When he was 16, would not let them date, or tried to prevent them from dating. Tried to prevent Melissa from leaving the house. Tried to prevent them from getting married. She tried to force Melissa onto birth control so that she could not get pregnant. Melissa's older sister joined that.
Okay, but is this testimony going to be coming from Christopher? Again, you're going to need for me to believe all of this, realizing that this is going to be a contentious thing. Again, a parent is going to take very, very personally if they're being accused of taking the life of their child. But also Christopher wants to not go down for taking the life of his wife. Knowing that there are two competing motives, and various motives from both both groups in this case, I'm going to need them to lay down more than you're going to hear from this. Hopefully we're going to hear like some concrete or possible letters. We're going to see something. Again, it sounds reasonable, and I'll give the defense that it is sounding reasonable, but I need to hear it, from... As a juror, I would need to hear this information from someone who didn't have anything to gain as far as, innocence or, exoneration of themselves, because they both seem like they could be motivated parties to, shift the blame onto each other.
Opposition to Christopher as well. We'll hear it admitted from her own mouth that she did not like Christopher. No one in her family liked Christopher. And that she tried everything she could, perpetually, to intervene in Christopher and Melissa's marriage to get Melissa to leave Chris. The evidence is going to show that any claims of abuse or bruises on Christopher's part only began to be generated after Melissa started working with Tina at Waffle House. And the evidence of claims of abuse only come from witnesses who came under the influence of Norma and Tina. Christopher and Melissa, as I said, had two children, Chrissy and Joey. Chrissy was born in August of 1995, Joey 11 months later. Again, the state is going to present testimony from Norma and Tina, who will say that Melissa would never under any circumstances have abandoned her children. She would not have just left and never kept contact with her children. Impossible. But we already know that, in fact, she did legally abandon them. And the evidence will show that she also practically abandoned them. As I said earlier, when Christopher and Melissa moved up to Brookline Street, the children didn't come with them. They stayed way back in Stockbridge. The children were raised by their grandmother, believing that she was their mother. In September of 1998, when Melissa started leaving for large portions of the time with her work friends and her new lover, Thomas Dixon, she rarely returned to Brookline Street, where Christopher was. She even less hardly ever went down to Stockbridge. You will hear testimony that she rarely visited her children during this time, and that she rarely ever even called them during this time. Whatever Melissa's own personal aspirations might have been in regard to her children, the one thing we do know is the evidence will show that she rarely ever contacted them, and all but forgot about them. You'll hear testimony from Christopher and Melissa's own daughter, who's now grown up, of course. Her name's Christina, some call her Chrissy. She will testify as a state's witness. She will say that she remembers to the day when her mother disappeared and all the pictures and belongings were moved from the house. Again, the evidence will show that she didn't live in that house. She lived in Stockbridge. The evidence will show you that at that time, Chrissy was every bit of 3 years old.
That does, again, I've had, from youngish children to now in college children, only one officially in college children level yet. But at 3 years old, I don't think either my boy children or my girl children would have consciously noticed and remembered, things of their moms going away. Now, they didn't have to deal with that experience, though, of, someone going away, at least at those ages. So I don't know, but it does seem like a memory that a child that young might not be able to hold on to again. I haven't heard evidence/one, or I haven't heard fact one. We've only listened to opening statements, but these are the questions that are going on in my mind right now. The defense is bringing up some things that I really do want to question, and that's part of the defense. Now, the state needs to have beyond a reasonable doubt. So the state should be able to say, yeah, we get that this is, a good thing to ask, but we've conducted backgrounds and we've looked at this, this, and this, and we've narrowed it down to Christopher being the only one with the means and the saw and things like that. That being said, the defense attorney, more than the state's attorney, is really drawing me in, and I think that he's doing a good job of being engaging and really pointing out things that he wants the jury to really note. I mean, he's really, making sure that the jury, when Norma gets on the stand, she's going to be heavily scrutinized. And I think that would have happened regardless, but I think now to another level, the jury has on notice, we need to pay attention to Norma because we are the ones that are going to be deciding whether she's credible or not. Or at least that's what would be going on in my head if I were a juror member.
Moreover, Christopher and Melissa's children didn't live in that house, as I said. Chrissy will also tell you that years later, she remembers Christopher making these offhand comments about he knows how to get away with murder, and the key is to hide the body, or to put it under the foundation of a house that's being built, so they'll concrete over it and no one will ever find it. And there are various versions of that story. Christopher's son, Joey, who's also now grown up, will also testify, and he will say he was in the room when such comments were made. And that Christopher was speaking in the context of the boasts that Carl Patton used to make, who was another girlfriend. We'll have evidence in this trial that early in their relationship, Carl hired Christopher to help him in the roofing business. Chris spent time around Carl and heard him say these things. Even Chrissy will admit that when Christopher made such comments, it was contextual within a discussion and had nothing to do with Melissa whatsoever. Chrissy will also admit that everything she knows about the case, she learned from Norma Patton. Remember what I said at the outset. The state's going to present little points of circumstantial evidence, and they're going to ask you to use your imagination to fill in the gaps. Here are some of the gaps I want you to pay attention to. The state will not present any evidence of a cause of death. The state will not present any evidence of a murder weapon The evidence obviously will show that there were remains that were discovered and that there were marks on the bones. But those wounds are all post-mortem. The state will present you with no evidence of how she died. The state will present no evidence of when she died or where she died. The state will present you with no evidence of where she was dismembered or when or how she was dismembered. They won't present any evidence of how she was transported to this site in the condition that she was. The state will provide claims about a saw that went missing from Christopher's work, allegedly around the time that Christopher was there. No evidence will show, even though the state claims otherwise, that he stole the saw from them, or that he was terminated for that reason. Furthermore, there's no proof that the kind of tool that actually made the marks on these bones was a saw. If so, what kind of saw? We have no evidence of what type of saw it would have been. We've got no evidence that will show that markings are distinctive of this reciprocating saw that was taken versus the circular saw he mentioned when he started his story. Furthermore, your common sense will tell you that there are about a literal million saws in the state of Georgia. Anybody can access a saw. Anyone can access a wide variety of types of saws. You'll hear from investigators.
Home Depot exist is not a defense, but it sort of is. But I don't think that that's a defense I've heard.
From the APD. They will admit that once Melissa's remains were identified, they searched Christopher and Melissa's house on Brookline Street. They searched every inch of the home, inside, outside, every room, basement. They sprayed the entire house with a reactive agent that discovers drops of blood. Not a single drop was found. They took paint samples from every room. Why? Because when Melissa's head was examined, there were chips of paint in her hair. There were synthetic fibers in her hair. And forensic evidence will show that. The fibers were in fact found to be consistent with some kind of a bath mat or even a carpet. Very broad category. When Melissa's remains were the paint samples of her remains did not match any of the paint samples from Christopher's house. There was no match of any fiber from Christopher's house. A pubic hair was found on Melissa's remains. Christopher willingly submitted his pubic hair samples. They didn't match. Head hair samples were found.
Did we have random pube on our bingo card? If we didn't, we now can check off that little spot on our imaginary bingo card of what in the Walmart rapture is this daggone case. But he is making good points. And again, this is making me want to pay attention as they get to testimony and really interrogate each of these, lacks. I mean, you do have these sort of gaps in information, though, with cold cases. The body was fairly decomposed, or at least the head, thus far we know, that was, in an advanced state of decomposition. And then the, limbs were denuded, for lack of a better euphemism. But the, soft bits were removed so that anthropologists could see the tool marks that were used in dismembering the body. But because of the amount of time and the length of time that had gone on between identification of the remains and Christopher no longer living in the house, it does raise some of these gaps, and the state is going to have to overcome that.
Christopher submitted head hair samples. The head hair samples didn't match. The medical examiners in this case made DNA analysis of the head almost impossible because one of the medical examiners or anthropologists soaked it in bleach. But the technology still won out in the end. The plastic bags in which the remains have been kept were recently re-examined using the most powerful DNA testing available in modern times, detecting trace amounts of DNA. And sure enough, one of those bags returned a profile that was viable for testing against subjects. it said there were at least 5 human contributors touching this bag. 2 of them were male. Christopher submitted his DNA. It didn't match. So the state has some huge gaps it needs to fill. And here's how we anticipate that they're going to try to fill that gap. We expect the state will also call a witness who is somewhat of an expert in the area of domestic violence or abuse. Perhaps you think, well, there's no DNA, there's no fiber evidence, there's no trace evidence in the paint chips, the really important evidence must be in the domestic abuse. But just as with the DNA and the paint chips and the fiber, etc., the expert will offer no support for the prosecution's theory in this case, and here's why. She doesn't know anything about the case. She's never interviewed Chris. She's never read a single police report. She's never even talked to the DAs about the facts of this case. Instead, she's simply going to say that she is a domestic violence expert and tell you signs and symptoms of domestic violence. We anticipate that their testimony on those matters will do nothing to prove that Christopher Wolfenbarger is a cold-blooded murderer. She doesn't know anything about him. She knows nothing. And we will ask you when trial is over to...
Now, that might be something that was argued in limine. A lot of these experts will have sort of the areas that they can get into, what they can opine on, really determined prior to the trial in motions in limine, or, you know, a voir dire of the, you know, expert witness to kind of let the defense and the state, both sides, interrogate what they were, you know, looking at and what they can talk about. So it might be that this expert can only speak in generalities. And the defense is, again, doing that, you know, getting in front of bad facts, because you have to think as a defense attorney that the jury has already heard that he is possibly someone who raises his hands to his wife. And, you know, you're going to have a lot of testimony from the state, which is the first thing that the jury's going to hear, as far as his, you know, propensity to lay hands on Melissa or to be aggressive or, you know, a bad partner. So he does kind of need to get ahead of that. And the way he'll do that is by saying, look, you know, their witness, their expert has nothing to do with this. And if he can slowly, brick by brick, you know, show that this kind of narrative of Melissa running away from Christopher, you know, has its nexus point from Norma, that's okay. Again, I'm open to that possibility. I am not sold on either side. I am just saying, as a juror, these would be things that I would be geeking out about. And as a me, I am currently geeking out about them.
Reject that level of fake expert testimony. Another thing, the state's going to offer evidence to say Christopher was the last person to see Melissa alive in December of 1998. You've already heard it. But other evidence is going to show that Melissa's sister, Tina, actually saw her the following spring. At that time, Christopher had already long moved out of the area. Although Carl Patton was serving 5 life sentences in prison throughout this whole period up until he died last December, that did not stop Norma Patton from firmly expecting he would be paroled at some point. And she began looking into his parole within about 12 years after his life sentence had been served, his first out of 4 or 5. And the law technically at the time allowed for someone serving a life sentence to be eligible for parole after 14 years of service in prison. The evidence is going to show you that Norma operated on the belief that the only reason Carl had not been paroled was because his son-in-law, Christopher, had not yet been arrested. She will state explicitly out of her own mouth in a police interview that she believed that as soon as Christopher would be locked up, her husband would be released to come home. And she worked tirelessly for years with the DAs, with the police, and with media campaigns to make sure that happened.
I do think that the defense attorney does need to be incredibly careful here, because while he might be making good points, there are going to be people who are very, very upset that he is going after a mother who, if you watch the video where I go over the article, she's kind of being lauded as the sole advocate for her daughter's voice. So depending on how kind of join this trial, if you joined from, one of these feeder articles or Zone 7, the criminal investigator, there are going to be a large population or a large segment of the people that are watching this trial, which is not so much important, but you've got to imagine that there's going to be some segment of the jury for which DV issues are incredibly, now this should have been eliminated through voir dire, but might not have been caught in voir dire, that DV issues are incredibly personal or can be very, very polarizing. So I do think that this defense attorney, in kind of going after Norma's credibility, which is something that he has to do, does risk alienating and possibly really turning the jury against him before the case even starts. I don't think he's been beyond the pale. I think he's been respectful. I think he's been pointing out, facts that he wants the jury to pay attention to, but I do think he runs that risk.
Ironically, the evidence will show that the investigators spent hardly any time at all investigating these other potential suspects. No hair samples were taken from them, no DNA samples were taken from them, no pubic hair samples, no searches of their homes, no paint chip samples taken from their houses. No one took DNA samples for this reason from the sister, or the accused molester in her home, or the friend down the road, or anyone else. The evidence will show at most that Melissa somehow died, and that someone tried to dispose of parts of her body. The evidence will show that everything beyond that is speculation and imagination. The evidence, as I said, won't show you a cause of death, a weapon, an instrument of death, an incident that led to her death, who dismembered or transported or scattered her remains. There will not be proof beyond a reasonable doubt in this case. There's no DNA, there's no high-powered technology, there's no expert testimony, there's no fiber evidence, no surveillance, no snitches, no co-conspirators, no confession, no eyewitnesses. The evidence will show that the state expects you to fill in all those missing gaps with your imagination. There is no evidence of these charges in this case, and that's why we will ask you at the end of this case to return a verdict of not guilty.
Thank you. Ladies and gentlemen, it's about 12:15, and so we are going to break for lunch, and when we return, we'll begin the evidence presentation portion of the trial. So it is 12:12, we're going to call it 12:15 and break until 1:15.
All right, we are going to skip ahead of the lunch hour. Ooh, time keeps on slipping.
Okay, we are back on the record after our lunch.
Before anyone asks me, I have no idea why Mr. Wolfenbarger is in a wheelchair that he just casually glides over in. Not one clue. But let's get into this. I have taken approximately 10 pages of notes, and we are just now getting on to witnesses.
Break. Mr. Wolfenbarger is present here in the courtroom. And the purpose of our gathering before the jury returns for the afternoon session was to discuss and see about resolving, giving y'all rulings on the photographs issue. So during lunch, I had an opportunity to review the email that Mr. Fawcett forwarded to me. That was an email from Mr. McDermott regarding his objections to certain photographs. I've also had a chance to review the flash drive that was provided to me, which was a PDF of the various photographs, most of which are not objected to. I think my understanding is that the state had attempted to limit the photographs to some extent, and that Mr. McDermott was accepted that many of them that are in the PDF would be admitted, and that the ones we have still pending as objections have been identified by Mr. McDermott specifically by number. And so I'd like to just sort of take them up in turn and understanding that the baseline here is these are gruesome photos because of the nature, the manner in which Ms. Wolfenbarger's body was disposed of, and that the manner in which the ME does its work and documents its work, that those things are necessarily gruesome and graphic. And so the question then becomes, are they relevant? And if they are relevant, are they overly prejudicial or for some other reason cumulative, et cetera? Mr. McDermott, if you want to start, I think your first one was photo number 35.
I'm trying to locate the file that has all
Sure,
I'm talking about.
that's fine.
I seem to have lost the email. Oh, I remember. Now I have that in the folder. Give me just 1 minute, please.
Yes, sir.
Okay, and the number again, please.
35, which, so it seems to me, and correct me if I'm wrong, but it seems to me that at least the first few that you're objecting to, 35 through 51, 53, you might have additional objections, but it also seems as if your objection is to them in that clinical context, in the medical examiner's possession on like a white table, as opposed to, for example, Exhibit 16, which is also a photograph of the head that was recovered, but in the field as it was discovered.
Yeah, I just felt that I don't see what that adds. It's not necessary to complete any part of the medical examiner's testimony, and I think it's just cumulative in that sense.
Okay. As we move on to 39 through 42, which again, I think it's fair to describe as sort of various photographs of admittedly a body part that I actually can't recognize by what it looks like.
Which one, the first one?
39 through 42, I just have them labeled generally as body parts. One of them might be a leg, but I don't know what I'm looking at because I don't have that training, so.
So again, we have pictures of.
And this would be a reason why a lot of trace evidence would be hard to find. Ooh, I think these might be real glasses. My poor husband has to deal with my chaotic self, and I may or may not have a collection of both fake and real glasses because I have eye bags owing to account on the fact that I have, 6 children and haven't slept in 19 years. That being the case, my husband found glasses, so that's always good. But these are some of the things you're going to run into, the degradation of evidence, the difficulty on finding a lot of trace evidence. All of this should have been something that the state really worked double, triple hard to try to make up for these deficiencies, because a colder case is going to have, some of these bits of evidence just gone because with time, witnesses forget things, stories, according to the defense, if you take their perspective, can be manipulated, narratives can be manipulated, motivations can be, maybe dual purposed or at least selfish at some point. Again, if you go with the defense, but if you go with the state, if you know these arguments are going to be made, then I hope that they crossed their T's and dotted their I's, because the defense has brought up a couple very, I would say things that I would be looking for as, at least issues that I'd want the state to cover.
Body, I think that exact body part in the field. We have a picture of the black bag just like that already in the field. I don't see what it adds to the medical examiner's testimony to show the same photograph in the same way, just on a different table instead of the ground. So I just think that's cumulative and unnecessary.
Okay, so I did look through all of the photographs, and although I did note there's a relatively close-up photograph of the head, Exhibit 16, in the field. I saw distant photographs and closer-up photographs. Maybe 21 is a closer-up photograph, but the rest of them seem to be in the field, seem to be in plastic bags, as opposed to the actual body part that was recovered from inside the plastic bag.
21.
Yeah, the 21, I agree with you, does appear to be one body part that was not housed in a bag, and the photograph is taken of it in the field, and it's a close-up. The rest of the photographs that I see in the field seem to either be not close-ups or of plastic bags. And I correct me if I'm wrong, Mr. Fawcett or Mr. Wilson, but I assume that the state's evidence is going to be that these were recovered to the extent they were in plastic bags at the scene, enough to ensure there were body parts in it, and then it was the medical examiner's job to remove those bags?
That's right, Judge.
Okay. And what about Mr. McDermott, 44 through 47?
Same objection.
I do like
And
that
then
this
50
judge is
I
taking her
don't even know
time.
what 50 is. Is it a tooth?
I believe that's, and this is from me talking to Dr. Terry, and
Yes,
she
sir.
wasn't even certain. But she thought it was like a top of the leg at the knee, and that's the cartilage between the knee joints, but maybe,
Okay.
maybe not.
Okay. This was, maybe because I don't know what it is or didn't recognize it upon seeing it, probably the least offensive of the photographs that I saw.
It's gory. It's almost like, rock collecting or something.
Right, but what is the nature of your objection to that particular one?
What does that do for the medical examiner's testimony? Because we're trying to get to the nature of the charges in this case.
Mm-hmm.
What does that lend to, relevant to her testimony or those charges? I don't see any necessity. So we've got, which one more body parts are in, doesn't really apply to anything. We don't even know what it is.
And she wasn't even sure. What were we talking about? I'm fine with removing that one, Judge.
Okay. We will remove 50. Okay. And then we move on to 51, which seems to be a collection of the various body parts. Is this after cleaning or before?
I think that was before clean. I think that was before, Judge.
Okay.
Oh, well, clearly some of the bones have been stripped of any flesh that was on them. So I think you're looking at some of,
Well, that's why I asked the question. Do some of those bones, did they have flesh on them when they were collected? I don't know.
I'm not aware from any description of what was collected in the field or taken from the bags that they were just bones when they came out.
Okay.
So I think these are all, or at least the ones that are just bones here, have been stripped by the medical examiner.
Well, certainly, I don't know why the top portion of the leg, I don't know why that would be, why that wouldn't be stripped, and the ones at the bottom would. But I know that some of the testimony that I expect is that there was at least one animal that had gotten to the bag. There was the possibility of other animals, because the body parts were out in a wooded area for several months. And I would say in hot conditions, which one thing the doctors would say is they can't, because of the conditions and the variables, they can't say what rate of decomposition there was. And the other point I would say to that is there's going to be some manipulation of the remains so that the medical examiner can examine and look at potential damage. For instance, I don't find anything particularly gruesome about just looking at a bone itself, especially one that's been stripped of flesh, if that's what indeed happened. But the bone in the condition that it is in the photographs when they examine it allow them to see the damage to it. That's what allows them to see the.
I mean, this is
appearance of
making
assault,
sense.
Striking the bone. So for that reason alone, that visual image should be allowed to be displayed for the jury. It aids testimony of the expert, and it allows for that expert to explain why they believe there are signs of assault on the bones of this bone.
Okay. And then I have 53, 54, 57, and 59, which at least to my untrained eye, in the absence of evidence, seem to me to be an effort to document alleged saw marks, tool marks on the bones.
Yeah, and I was trying to make an effort to include at least one example of each one of those that's independent. But where they're double pictures of the same thing, I think it's cumulative and unnecessary. That's also why I think that, we've got these close-ups where there are tool marks. That's why we don't need a whole table with bones laid out. That you can't see any tool marks from that distance anyway. That's just cumulative and gory for no other reason. Doesn't document anything the medical examiner did except take the flesh off the bones. But, and maybe I missed one, that's fine. I'll hear.
No, I think that it shows the remains that were recovered in totality. So I get what he's saying in that you can't see the tool marks, so why do we need that? But I think it also goes to show what was recovered and what still remains outstanding. I think part of this case is that they haven't found the torso. I mean, that would be a big thing for me as a jury. What happened to it, or was maybe there. These are things you can't speculate as a jury member, but again, the fact that they didn't find it, I do think is relevant in this case, and I think can be illustrated by the fact that those bones are there and we're not looking at a full intact body.
About it, but as far as going through the list, I tried to include one example of each specimen that had tool marks that was unique. And I only object to the ones I thought was cumulative.
Okay.
Yeah.
Just one second, Mr. Fawcett, because I am going to let you respond. So to be clear, I didn't just limit my review to the numbers that Mr. McDermott mentioned, right? I was looking at them as trying to take them as a whole with particular attention to the ones that you had asserted, looking for things like needless accumulation that would just be gory for no reason versus particular reasons. Again, without any context, I don't know if, for example, 53, 54, 55, 56, 57, 58 are different bones with saw marks in them or different angles of the same saw marks on the same bone.
I can't tell you with definitive accuracy, but my inclination was 54, 55 were the same, just different angles.
And Mr. Fawcett, the point of my asking that question is I believe that the presence of tool marks and the demonstration of them is relevant. Nobody's going to enjoy that process, but it's relevant and needs to be presented.
Very good point.
If it is different bones, right, saw marks on multiple bones, I don't think that's cumulative. If it is, unless you anticipate that the medical examiner is going to say that there is a specific reason for two different photographs from, say, two different angles or something like that of saw marks on the same bone, then I would ask the state to endeavor to further limit the photographs. Yeah. So
the reason you might need two angles off the top of my head, if there's a stop-start. So if you remember on the Chandler Halderson case, I can't remember exactly, but it was a saw that had, you could saw forward and back. I think it was called an all-directional. Look, I'm not a sawologist, but she had to show bones multiple ways to kind of show that the saw essentially jumped, like it didn't make a deep enough groove on that first. I'm thinking about cutting firewood because we have a wood burning fireplace and stove. So when I would, start trying to, saw some of the bigger branches into little bits of wood, if you don't push down hard enough on the saw, or I just suck at it, it would kind of bounce around, but it wouldn't actually make a groove indent to kind of guide it to cut things. So you might need different angles, but I think that this is something that the medical examiner or the anthropologist should have really clearly noted in her report. And then the state wouldn't be saying, well, I don't really know if they're the same one or not. So you would think that the state, again, knowing that there are probably going to be these challenges, would have anticipated that and said, hey, the anthropologist needed several, angles on this to show that there was hesitation or something. I don't know, something science-y.
that's okay, sorry. So to Mr. McDermott's point, if it is three angles of the same saw marks on the same bone, then perhaps one would be sufficient, unless you're going to tell me that the medical examiner has a particular reason for having taken that photograph in the manner at which it was taken in order to enable them to conduct their examination.
In light of that, I would propose taking out Exhibit 55, 58, 59. I believe that would eliminate, and the intent of including 55 and 54 was that the different angles I think would aid in testimony, but I think that the expert can testify based off of the one photo. So I would propose taking out 55, 58, and 59.
Okay. So
Your Honor, did I already object to 53?
you did?
Okay. I'll wait till, did we talk about that one yet?
No, I wanted to start with the saw marks because it appeared to my eye that your point was that, and I thought that was correct, that there were multiple angles of the same saw marks on the same bone, and absent some particular showing of necessity of multiple angles of it, I wanted to see if we could pare that down. Now, going back to the 53, really it's the group of photographs from, say, 39 to 53, which are the various body parts. As a general proposition, their existence and condition in the field is relevant and admissible, right? Those photographs that document that, as long as they're not cumulative, as long as we don't have 7 photographs of the same thing. I believe that starting with 44, it might be, well, no, I think all of them are. Starting with 35 through 53, they're all in the ME's office, right? Those are all as part of documenting. Okay,
Yes, sir. Yes.
thank you. Other than, Mr. McDermott, is your argument that, I think I heard one argument, which was that they are the photographs 35 through 53 are cumulative of photographs in the field and don't need to be shown again? Do you also assert that photographs between 35 and 53 are cumulative of one another, that there are multiple photographs?
In some cases, yes, Your Honor.
Okay. So the same request I made earlier, Mr. Fawcett, and I trust that you endeavored to already do that. But to the extent that the photographs taken in the medical examiner's office are necessary and relevant to demonstrate how the examiner examined the remains to arrive at their opinions, I think those are relevant and admissible despite their graphic nature. Thank you. But I would also want to avoid needless repetition of the same photograph.
In further, further to apply to the court's instruction, I would propose eliminating 39, 38, 35. I believe that would eliminate the two photographs of the head. That would just be the head and the field. 39 would be I believe, looks like a knee portion to knee. There would still be that photograph of that in the field.
I do like the care that I think all parties involved, and it's from different perspectives and different motivations. The defense obviously doesn't want to have a lot of gruesome photos to kind of prejudice the case against their client. The state wants to comply with the court's ruling, and I think the judge is being very respectful and mindful of the realities of the case that she's trying, that these photos are gruesome and they're going to have to be shown. But, limiting the kind of repetition and being thoughtful about it. I am impressed with this judge as of right now, taking her time to be thoughtful and really go through and look at each photograph to make sure that, the jury is seeing what they need to see to decide the case, but isn't being overwhelmed with repetitions of the same thing.
I benefit the jury that it's not as close up as that. And then 35, which is the neck. No,
35 is the head.
35 is the okay. So then I would take out 38.
Okay.
And I think 36 and 37 are representative of, I think, both sides of that neck column. So I would propose that.
Okay. Mr. McDermott?
Well, I'm fine with those deletions. I would also ask that 53 be deleted because it's repetitious of 56. And although I think there's a question to be asked fairly, on 53, you can see the kind of connective tissue at the far right side. If that was part of the examiner's testimony, that's how part of how the leg was removed, or something of that nature, it would be more relevant. But I would say choose between one of those two photos. I would prefer 56 because it's less gruesome.
53 and 56.
They're the same bones from different angles.
Mr. Fawcett?
I'm fine with that.
Okay, so which one?
53.
I'm sorry, you'll remove 53 or you'll remove 56?
I'll take out 53.
Okay. So what I have so far is the state has agreed to remove 35, which is a second photograph of the head, even though we have a close-up of the recovered head in the field, which is remaining in evidence. That the state has agreed to withdraw 38, 39, 53, 50, 53, 58, and 59. So with those agreements to remove those photographs, Mr. McDermott, other than your objection to the nature of the evidence and its graphic nature, et cetera, do you still specifically have other objections you wish to make a record of?
Unless I wrote them down and you have it?
Yes, sir.
Then no.
Okay. Well, to try and be as clear as I can, to make the record as clear as we can, Mr. McDermott moved to exclude 35, and 35 has been voluntarily withdrawn by the state. Mr. McDermott did not move to remove 38. He did move to exclude 39 through 42. The state has agreed to remove 39, but to keep 40, 41, and 42. So to the extent necessary, I'm going to deny Mr. McDermott's motion to exclude photographs number 40, 41, and 42. Mr. McDermott moved to exclude 44, 46, and 47. I'm denying that motion. As to Mr. McDermott moved to exclude photograph 50, the state has agreed to remove that one. Mr. McDermott moved to exclude 51, that motion is denied. Mr. McDermott moved to exclude
It
53.
happens.
53 has been voluntarily withdrawn by the state. Mr. McDermott moved to exclude 54, 57, and 59 that are various angles of saw marks. Other photographs in the packet that the state has offered, including 55, 58, and 59, are various angles of those same saw marks. And the state has agreed to withdraw 55, 58, and 59. And based on that showing, the defendant's motion to exclude 54 and 57 are denied, and the defense's motion to exclude 59 is granted because the state agreed to withdraw it. Anything else, Mr. McDermott, about the photos?
No, Your Honor.
Okay. Mr. Flessette, anything that we need to take up before we get started with the evidence?
No, Judge, if I could just have a few minutes to take out the exhibit.
I was just going to say, yeah, and I'll run through them again. You have, my notes indicate agreed to withdraw 35, 50, 53, 58, 59.
Is that going to give me enough time for a comfortable break?
Yes, although I do have all my jurors, so as soon as y'all can get back and be ready, we'll be ready.
Okay, let's see if we can actually get to a witness.
Order 2 days ago for Mr. Wolfenbarger. He's still not been allowed or enabled to have a haircut. If I could ask the two of y'all to please prioritize that and communicate it to whomever you need to so that that can happen today in advance of tomorrow, I'd appreciate it. Thank you. Anything else, Mr. McDermott? Okay.
I do like, again, you might not like this defense attorney because of how he's presenting his case, but in as far as making sure that his client looks presentable and, is presenting the best, appearance he can to the jurors, I do think it was appropriate for him to ask if he could get a haircut because his hair does look a little wild and untamed. So, again, I think this is a good thing. And I think the judge, keeping the, deputies and bailiffs responsive to that is good too. Again, if you believe that Christopher Wolfenbarger is the monster that did this to Melissa, then you want to make sure that there is no level or no chance for an appeal. And you wouldn't want something as stupid as his denial of a haircut, to possibly be an issue later on.
We have everyone back, and I'm told that we have all of our jurors. Are we ready to get started yet? I don't want to rush. Mr. Facette ask for a moment.
Yes, Your Honor. I just would let the court know the first witness does require a wheelchair.
Okay.
So he may take a little bit of time. Should I go ahead?
Is that person going to be able to get on the witness stand, or are they going to, we're just going
Probably
to?
on the side or the front or however you would do it.
Okay. Are we concerned at all about volume?
Can't know until he maybe.
Okay.
Is there a portable mic that we can get a hold of?
Technically, these things, although they are affixed very well, are in fact removable if it came right down to it. I'm not worried about the jury hearing that person. I'm worried about the court reporter and the other people in the courtroom.
You mean this?
To next one?
Yes, sir. Like the whole base.
I mean, you can do it. And he's going to be right here.
Okay.
That's what we do.
That is the best way to do it. Okay. State's ready. Mr. McDermott's defense ready?
Yes, ma'am.
Okay, we're ready for the jurors.
All right.
Please be seated. State may call its first witness.
Thank you, Your Honor. State calls George McKeecher.
Okay.
Oh, wrong one, sorry.
And if you'll turn around, sir, so that you'll be facing sort of this general direction towards the deputy, where the deputy's standing, if you can. Turn a little bit more so you're facing the deputy, so you won't have your back to the jury. That's good, sir. Now, are you able to raise your right hand, sir? Okay. If you would, thank you.
This is Mom, you're about to be forced to make a statement of truth, the whole truth, and nothing but the truth. You may lower your right hand, state and spell your name for the record, please.
George, W. McPeakin, last name spelled MC, EA,
Okay. Mr. McEachern, this is the judge talking.
Sorry, I am going to his volume is incredibly low, so hopefully she is admonishing him to be a little louder.
I'm behind you, so don't worry about that. If you could, just because you don't have a microphone, if you could just try to speak up when you're answering questions to make sure everyone in the courtroom can hear you. Okay, sir? Thank you. Go ahead, Mr. Wilson.
Thank you, Your Honor. And you live in Atlanta, sir? How long have you lived there?
28 years.
And did you ever live in the area of Avon Avenue, in the general area? Do you still live there? How long have you lived at your present address? Yeah. Okay. Thank you.
Do what?
What did you do? What did you do for a living?
I want to thank for my son.
I apologize. We can't hear him.
Hold on a second, sir. Should I try to get the microphone?
I'd say give it a try.
Yeah, because I have no idea, and I have bumped my volume up to where it's bothering my ear, so.
Yes, please. It's coming now. I can see it moving.
Destruction of court property. This case is crazy. What is going on? Yeah, this trial done already started out as circus, and it is definitely more crazy than any other case that I think I've had.
You see if you can get closer to the microphone
for
that
the
we have
first
there for you, sir.
witness.
Yes, sir. Mr. Yes, for now. Hang on. I apologize. Why don't you have him come to the podium, and against all directions, we're going to have him move. We're going to move the microphone. Thank you. Just bend it down towards me. I'm going to have him right here. Yes, ma'am. And then, Mr. McEachern, if you could turn a little bit more and face the jury, please, sir. And now.
Yeah, hopefully we'll be able to hear him because he's incredibly
Yes, George
soft-spoken.
W. McEachern.
Much
Last-
better, sir. Thank
Last
you.
name spelled capital MC, capital EACHERN.
Thank you, sir. Go ahead, Mr. Wilson.
Thank you, Your Honor. And do you remember in April, at the end of April of 1999, unusual thing happening an unusual thing you found on Avon Avenue?
Yes, I went for a walk that morning to the bank, and on my way back, I came up Avon Avenue, and as
And what did you see?
I saw a head, a human head that was laying in the street. So I walked up to it, and I looked down at it, and I saw it was a head.
How did you know it was a head?
Well, through my training in martial arts science and funeral directing, I recognize human heads.
Human head?
Yeah.
Wow, of all the people to pick up or walk by and find this, skull, it would be someone who had worked as a funeral director and in mortuary or had an educational background in mortuary science. So, unfortunate, and I wish he didn't have to find this, but of all the people to have had to find this, at least it was someone who knew what it was, knew who to call, and treated, I'm sure, knew that these remains needed to be treated with dignity and respect.
What did you do?
I took a stick and I moved it out of the street to the curb of the road.
Why'd you do that?
So it would be intact. I didn't want anybody, another vehicle to come and crack it up. So I moved it to the corner.
Could you repeat the last part where you said that it's a crack it?
I did not want a vehicle to come and run over their head and deform it. Because I saw it belonged to somebody.
What did you use to move it?
I broke off a stick. And I took the stick and I tried to push it over to the curb.
Did you see anything else unusual on Avon Avenue on that day? I mean, was there any other things that you can recall?
Well, I didn't know some birds, some birds flying up in the air, look like buzzards.
Okay.
And I recognized that might have been the reason why they were there. But I told the officer after I called them that I thought they could be something else out there in the woods because the buzzards were still there.
Okay. Now, after you found
He's saying buzzards. The closed caption isn't quite. So vultures, birds of prey. If you live out in rural Indiana and, there happens to be roadkill, these are the birds that you see cleaning up the roadkill. So it's a good educated guess, but I did want to clear up that it's buzzards or vultures or, carrion birds. Because the closed captions was having just a scotch of a problem with what he was saying.
after you found the skull, what did you do next?
I went home, I got my daughter, because she was in criminal justice,
Okay.
and I wanted her to see the head.
Okay.
Yeah.
And did your daughter come with you?
She did.
And what did you do next?
Called the police.
Okay.
Called 911.
And after you called 911, how long did it take? Do you remember how long it took the police to get there?
That recognition survey right now. It wasn't long. But right now I can never recall how long it was.
Okay.
But they
You didn't think
did.
it was long?
No, I didn't think it was long. But
How
they,
many police, do you remember how many police showed up?
no.
Was it just one or more than one?
I don't know. I know there was one.
Justin, this case is 27 years of crazy in 3 hours, and we have yet to scratch the surface, or so I'm told. Now, yes, he randomly found a head. Now, it does seem like the person that left the remains of Melissa, the head and the limbs, picked an area that was very close to both the previous marital home of Melissa and Christopher, but also where Christopher worked at a glass factory. So, yeah, I have no idea. This is an interesting case. The state of Georgia is trying to prove that Christopher Wolfenbarger took the life of his wife after a very fraught relationship. Now, according to Melissa's relatives and even court documentation and police officers, there were instances of DV in this relationship. Now, the defense claims that these were all overstated by Melissa's mother, Norma, who happened to also help assist her husband in about 4 or 5 murders in the 1970s. It gets weirder. So Melissa disappears around 1990, 98, now around Christmas. Now, again, that is also going to be in conjecture because the defense is going to state that Tina, Melissa's sister, actually saw her in the spring of 1998. Now, in 1999, these remains were found first in two separate incidents. So at first, the head was found by this gentleman. Now, it was in an obvious state of decomposition. This gentleman stated at the beginning of his testimony that he had an education in mortuary science and used to be a funeral home director. So when he did walk and come across this head in the middle of the street, he basically took a stick. I don't know how sciencey that is, but essentially got the skull out of the street so that it wouldn't be run over by cars. After he decided to call his daughter to tell, her that he had found a skull, they called 911 and that. Then it was misidentified because some of the markers on the skull, because there had been, decay and possible maybe even animal involvement in some of the remains on the skull, it was classified as a male skull. So they were just looking for a possible missing person. They were doing all of the things that you do in order to try to get a positive ID on the skull. Well, about, I think a few months later, they return there and find limbs. And again, the limbs and the skull were found relatively very close together, but there were no links until 2003. Now, in 2003, Melissa's father, Carl Patton, is charged with the 4 and then eventually 5 murders that were the Ridge. Is it? I know it was the Ridge River. The Flint River, I'm sorry, the Flint River murders. So yes, so the head, arms, and legs were found. The torso has never been found. Now, the defense is putting up a third-party culprit because they point out that Carl's victims were all close associates or family members or friends. So it's not out of the realm of possibility, according to the defense, that the parents might have, something to do with it. Now, Christopher, again, the state brings up that they were in, a chaotic and somewhat violent relationship. Now, 7 days before the family last claims that they saw Melissa, Melissa goes down to the police department and requests a protective order against Christopher. There are signs and police reports of bruises and markings being on Melissa. About 7 days after taking out that protective order, she goes back to the courthouse and decides to remove it. Now, yeah, so this is witness one because we have already had effery beyond the pale of everything else. So essentially, the too long didn't read is that the state alleges that Christopher Wolfenbarger basically took his wife's life, dismembered her, and left the remains close to where he worked in kind of a wooded area. The maps that they're going to use right now, Google Maps, the area is much more built up than it would have been in 1998, 99. So it was much more wooded. So that is what the state is going to say. Now, the defense has brought into focus that there is no trace evidence, no DNA evidence, no, hey, we searched their house and it glowed like the day is bright because of aluminol. So there are not a lot of, substantive links, which is not uncommon with a case that's been cold for nearly 26 years. But there is a lot of additional stuff that is going on in this case, and we are only scratching the surface of crazy. This gentleman is the one that found the skull, and this is going to start to kind of set this case into motion, even though it was a long time before she was positively identified. But finding the skull is going to be kind of the first thing that takes Melissa Wolfenbarger from being a missing person and an adult that might have, and in fairness to the police, an adult who is 21, who in all, possibility might have gone and started a new life in California. I mean, there weren't other leads that were, showing them that she had met with foul play at that point. So that's what you have. You have the defense basically stating that, look, there were a lot of shady people in Melissa's life, and Melissa and Christopher weren't even really, they weren't even really technically married or living together at this point. While they were still married, Melissa had signed over the rights to her two children from, the marriage to Christopher's grandparents. Now, Christopher's mother is going to testify that Melissa made very clear to her when she relinquished parental rights and asked for her mother-in-law to have custody of her two children, that it was with the sole purpose that, the Pattons not get the children should anything happen to her. Again, the jury's going to have to decide, with all these competing motives, with all these competing narratives, who do they believe? So case is going to be, a very interesting one to kind of go forward to, because there's a lot of competing motives and a lot of things for this jury to have to figure out in a very old case with not a lot of, the kind of CSI evidence that we kind of think of as kind of a necessity in a lot of these cases. Do you have DNA? It's usually one of the first things that's asked, do you have trace? Do you have forensics? I mean, so this is going to be a hard case for the state, but the defense also came out very strongly against Norma Patton, sort of the woman that, if you watch my short video about this case, the mother of Melissa, who, if you read the article associated with that, kind of led a 26-year one-woman, journey for justice for her daughter. So the defense really does have to point these things out, but they do risk alienating the jury by attacking what the jury might perceive to be as, this innocent mother. Now, Norma did confess to helping hubby Carl off too, or either accomplice after the fact or something. She helped with the, murders that Carl did. Now, Carl Patton, the serial unaliver and father of Melissa, did pass away this past year. And y'all, that's not even half of the crazy that this story is, but let's get back to it, because we'll be here forever with me trying to explain it with like 12 murder boards and Norma Patton. But almost apropos at this point.
I do know there were one. There could have been more than one, okay?
Because you talked to the one?
Yeah, I talked to the one, yeah.
Okay. And did you go anywhere after you initially told the police out on the scene? Did you go anywhere with the police?
I do know I had to go downtown.
Okay.
But I can't recall whether it was the same day or not. I was there a few days later. But I do know I went down to the Atlanta Police Department.
And Justin Smith, sorry, almost lost your question, but yes, he is in jail. And that actually came up as a pertinent point, because the defense had asked that he be able to have access to a haircut so that his hair isn't so wild. And apparently the jail has not given access to a haircut. So the judge did tell, I believe, the sheriff's office or whoever is in charge of his transportation, that she requests that he have a haircut by tomorrow, if at all possible.
I think it was down there, Georgia State College, Ponce Leon, somewhere down in there.
You went to the headquarters?
I went to the headquarters, I think it was.
And
You-
I assume you told them what you saw?
I told them the same thing, I'm telling you now, yeah.
And do you remember if you gave any statement or had to sign a statement or anything, just saying what you did?
I'm pretty sure I had to, sir. I'm pretty sure I had to.
I'm gonna show you a piece of paper. Do
Okay.
you recognize that? Mm-hmm. Is that your signature?
That's it, sir.
Yeah, could you read it real quickly? Is that the statement that you gave?
Sir, I'm gonna be honest with you in the courts. When I gave this report, I was walking, I was younger, I could see better,
Well, can you read it?
and right now, I cannot make this out. That takes too damn around. I don't,
I love this witness. He's like, Your Honor, I'm not going to lie to you. I didn't bring my readers here. This is in .4 font. Like, does someone want to, like, guesstimate what these letters are and I'll try to read it? Oh, bless his heart.
have my glasses with me.
Are they round?
I don't know, but baby, have my glasses like that.
Oh, he's like, Babe, do I have my glasses? Bring him his glasses. Okay, now the evil sadistic person in me is, okay, my inner child is a butthole, but she's funny as hell because you know what she just flashed me? Now it's going to be completely dark humor and not everyone's cup of tea. But all I'm getting in the back of my head is the flash from My Girl. Where's his glasses? He can't see without his glasses, which is completely inappropriate and I shouldn't be internally giggling. But there you go. As a view inside Mo's mind. Watch your step, mind the gap. All of them.
Mr. Wilson, just to clarify, are you asking the witness to read it to himself or are you asking him to read it out loud?
Read it to himself.
Thank you.
Refresh his recollection.
Okay. Look at the mirror. Thank you.
Do you need some assistance, sir? Apparently not.
What you want me to do with this?
Does that help you?
Yes, you may read it to myself.
Yeah, read it to yourself real quick.
Okay.
Oh, okay. I will say that, this judge has been very professional in trying to figure out how to accommodate this witness and still have him mic'd up. Yeah, I think,
It's true, all but a few, maybe a few sentences.
Do you know?
I was driving, I wasn't driving, I was walking at the time.
I apologize. I think you
Say that
said,
again?
yeah.
I wasn't driving, I was walking at the time.
Okay. Does that help refresh your recollection
Yeah,
at all?
sure, it does.
Do you remember finding anything else other than a human head?
I don't.
Now, how long have you lived? You've lived in Atlanta your whole life?
No,
Where else did you live?
no,
How long have you lived in Atlanta?
ever since 1960.
Ever since 1960? And Avon Avenue, is that located in Fulton County?
It is.
I just have one moment, Your Honor.
Sure. Thank you. Mr. McDermott, questions for this witness?
Just a couple, Your Honor.
Sure.
Good afternoon.
Hello, sir, how are you?
Just a couple questions.
Okay.
You said you informed the officer on the scene that there were buzzards circling overhead. Is that correct?
I did.
And did they go over and check?
To your knowledge?
I don't know, they told me they were going to, but I think what happened, a few days later, somebody came by my house and told me that they had found another body part, and they were going to try to match the head with that body part. However, as far as I can remember, sir, it wasn't in Atlanta they had found that body part. I think he told me to find somewhere near Griffin, Macon, or somewhere down in the area. It was something he told me that he had found a body part, and they were trying to mess it up. And that's the last I heard of that.
Is this a walk that you took every day or frequently?
No, this was a walk that I decided I wanted to walk that morning to the bank.
Did you ever normally travel up and down Avon Avenue?
Sometimes.
You ever notice any dogs?
Brother, there are homes in that area. I'm sure there's dogs in that area
Or did you
also.
ever see any when you traveled up and down Avon Avenue?
Yeah,
I don't know.
All right, thank you.
No.
That's all the question I have.
Thank you. Mr. Wilson?
No redirect, Your Honor.
Okay. Mr. McEachern, you are excused as a witness. Thank you very much, sir.
Thank you, ma'am.
Okay.
All right, Dale Kelly.
And if you could move that mic back, and then we're all going to try not to touch it again. Thank you.
All righty.
Careful. That chair is on wheels and there's a
Oh.
ledge next to you, so make sure and stay closer to me than the edge, okay? Thank you, sir.
D-A-L-E, Kelly, K-E-L-L-E-Y.
And what do you do for a living, sir?
Retired,
What did you do before you were
law
retired?
enforcement for 42 years.
And let's go through your law enforcement career. Where did you first become a law enforcement officer?
In 1979 in the city of Atlanta.
And when you were hired, did you have to get, well, tell us about your hiring at the city of Atlanta.
July 2nd, 1979 was the first day I started the Atlanta Police Academy. We were there for 12 weeks, and then after you got out of that, you rode with a senior officer for 12 more weeks in field training. I became a patrol officer. I was assigned to Zone 1, which is northwest Atlanta at that time. 83, I was promoted to detective. I did vice for about 6 months. That was during Eldon Bill. He thought all new detectives needed to go undercover and then come out and get in a regular division. I went to sex crimes. I worked in sex crimes, total of 13 years, but whenever they had a sexually related homicide, I would get pulled over and help the homicide detectives work a sexually related homicide. And then in 1996, I was permanently assigned to homicide.
In 19, were you post-certified?
Yes.
Are you still post-certified?
No, I do not keep my mandated.
Okay. And when did you leave the city of Atlanta?
I retired in 2000 from the city of Atlanta, went to the Douglas County Sheriff's Office, worked there, started in the jail, worked patrol. I went to CID. From CID, I made sergeant. I was a night shift sergeant for a patrol shift. And then I went to the fugitive unit, the warrant unit in plain clothes. And then from there, I made lieutenant and was over the transport and civil division.
Now, did you receive any specialized training in investigations?
Yes, I mean, I've been as far as California on missing persons, violent crime network training. I've been to Valencia College 3 or 4 times on advanced sex crimes, advanced homicide, crimes, and like that.
Now, during 1999 and around April, could you describe what you were in homicide division at that time?
Yes, sir.
Tell the jury what happens when you get.
JKD Buck, I blame you for this, but do you know who his face reminds me of now? And it's the spitting image. The rest of the body, not so much. This man was in Mary Poppins as Mary Poppins' like alcoholic uncle. You know, the one that let the kids, you know, sit at the table floating near the roof. He might have also played Ben Franklin. I don't remember if Sam Elliott and Michelle Palin had a son.
How does that work? Or how do you get assigned cases or what?
Well, okay. You were on a rotation system where you were up on call. And if anybody called for a homicide unit, you would answer and go wherever they asked you to go. You didn't go by yourself. Half the time, the whole unit would go. You were just the lead, and they would do other jobs needed at the scene.
And when you say lead, what does that mean to you?
You were up on call, and the case was going to get assigned to you.
And when you're lead, what kind of things do you focus on?
Well, you get to the scene, try to focus on directing the identification people to do fingerprints some places, sometimes you don't, take pictures and stuff like that. You may ask some, like the officer, the first responding officer, if there's a witness at the scene or something, you get the officer to take himself and the witness to the homicide office where they could give statements.
And let me draw your attention specifically to April 29th, 1999. I assume you were on call that day.
Yes.
And did you receive a call regarding a unexplained, well, I mean, what kind of call did you receive that day?
The way it works is Zone 3 Unit 2304, which meant he was a day shift unit working 304's beat, came over with detective radio and called for a homicide unit. Each zone, and Atlanta still has 6 zones, they all have their own radio frequency. Detective division had their own frequency, and they would just switch their radio over to the detective frequency and call for a homicide unit.
So it was your turn?
It was my turn.
And where were you told you needed to report to?
He told me to come to the intersection of Avon and Hartford Way, southwest in Atlanta.
And what did you do?
I got in the car with the lieutenant, and investigator Tina Miller also rode with the lieutenant, Tony Biello, and we rode to that location.
And why did Investigator Miller accompany you?
Again, on a homicide, you need as many people as you can out there. We didn't know what we had other than a unit calling for us, and we could always use help.
And so she went along?
Yeah.
Okay. And when you got to that location, what did you observe?
When I rolled up, there was a decomposing head in the road standing upright. There's an old black plastic bag to the side, and there's an old mangy, like a stray dog with matted hair and all, kind of nasty, running around out there.
Okay. And do you recall where that skull was located?
It was on the side of the roadway
Yeah, it'd been moved by a stick. Just helping out.
well, it was actually on the Avon side, because we used the address of 858 Avon Avenue.
Now, when you're investigating a crime scene, is it important to document information?
It is, yes.
And you document through reports and also pictures?
Well, I didn't take the pictures. I called for our ID section to come take the pictures, and it's up to them to document their pictures.
Okay. No, what I mean is that it's important to take pictures of
Yeah,
crime scenes,
yeah,
right?
yeah.
Okay.
Now, there was some evidence, and some of the reason that there might have been some scarring of some of the kind of the planes and measurements they take on the skull is because there was speculation and a little bit of evidence. Yeah, no, these are an old prescription. That animal activity had occurred on the remains, especially the head. There was some evidence that the bag might have been moved out into the middle of the road, and especially this dog is going to become kind of important. It's alleged that this dog had to be kind of shooed away from the crime scene and the area several times by the police detectives as they were trying to gather evidence. So And with, it being a wooded area, with essentially, meat left out, obviously there's going to be animal predation. So that might have caused, Sarah, this is the part that I have a problem with logic wise. So if I go with the state, and we do know that criminals are dumb, and that the area was mostly rural and wooded at the time, I still don't understand why, if disarticulation is generally to hide the identity of a body or make identifying a body more difficult. Now, the limbs and the head were all located in an area centrally kind of close to both the marital home and where Christopher was working. So the only part of the body they didn't find was the torso. So he either has to be the worst criminal, which we have seen there are many criminals that fail logic, but the fact that the head and identifying limbs, so fingers, were found, does kind of make me wonder why you go through the whole, rigmarole of dismembering the body if you're going to leave the identifiable parts in the woods unless you thought the animals were going to take them. Also, I realize that criminals don't always engage in forward thought. So sometimes they're just like YOLO. So I'm trying to attach my logic to this problem, and I'm having a hard time with it.
May I approach a witness, Your Honor?
Yes.
Now, in answer to your question, Sarah, the defense is going to heavily imply that these remains weren't found until the mother and father were going around and trying to find either Christopher or Melissa. And when they went up to this general area, they realized that Christopher had moved out of the area. The marital home was cleaned out. And there's been inferences that possibly you could, you could see that Norma and Carl, two people who, well, for all intents and purposes, have a history of homicide, could have placed these here. Now, that being said, there's not been an iota of evidence put out as this. This is the second witness, but the defense has put up some credible, I think, issues with this case as far as some of the lacking trace evidence. And I think it's really going to be dependent. I am looking forward to the mother testifying because I think that the defense could really be overplaying their hand if you have jurors who are not fans of the defense attacking the mother of the victim. Because essentially, the third party defense is that Melissa had a boyfriend. She and Christopher's marriage, according to the defense, was essentially over at this point, and she was spending time with a boyfriend. But you also have the father, and the defense has alleged that Melissa was aware of her father's past murders and possibly was silenced by her father. Again, these are all inferences that the defense has made, and they might find, they might find seeds and it might germinate into something that the, jury would want to look at, but it might also backfire. I plan to finish up this witness, and then I'm going to go back and actually look at the comments on both Law and Crime and Court TV as the defense is giving their opening statement, because I want to see how other people are taking this in, because I do know a lot of people are not going to like this approach.
I'm going to show you what's been marked as State's Exhibit 3 through State's Exhibit 20. Would you please look at those and tell the jury what those are?
They're pictures of the general area of where it was located, and ID had saw certain objects. They put the little plackets up at, and it's,
Could you look through those, please?
yeah.
Thank you. Those true and accurate pictures of what you observed that day?
Yes.
All right, at this time, I'd ask to admit states 3 through Exhibit 20, which are photos of the scene.
No objection.
Okay, Mr. Samuel, thank you. Exhibits 3 through 20
We are not going to
admitted.
see these.
And I would ask to publish some of the pictures to the jury as we go through the testimony as far as
Okay.
warning.
Thank you. That's what I was waiting for you to ask.
Yes.
So, ladies and gentlemen, as we discussed during the
The jury is going to see all of these pictures. However, Law and Crime and Court TV and any sort of streaming service is not going to show these pictures. We have been led to believe by the amount of time that was gone over to make sure that there were no cumulative photos of these, that they are, again, body parts in various states of decomposition with possible animal activity. So they're probably akin to the Chandler Halderson case, or even, sadly, the Gannon Stout case where there was advanced decomposition. So these aren't going to be easy photos for the jury to see. And obviously, we're not going to see them because, well, YouTube doesn't like it. And it's usually, the judge says no streaming.
process of jury selection, I told you that I would warn you when we were going to show you photographs that are maybe graphic in nature. So I'm giving you a heads up that some of these photographs may be graphic in nature. Thank you. State may proceed.
Thank you, Your Honor.
This man reminds me of me. He's like a fidgety guy.
Okay. Show you what's been marked as, or what's been admitted as State's Exhibit number 3.
Oh,
You kind of describe
no.
the picture in detail for the jury as best you can.
Hello.
It's an overall shot of the area where the head was found.
Can you speak up a little bit?
Sir, I'm sorry.
If
It's
you
a
could pull that microphone towards you, I think that'll be easier as well.
I don't think it's graphic. Look, I'm gonna let y'all see it. I don't think it's terrible, but I also don't think that YouTube's going to have a big issue. Obviously, it's covered by the placard as of right now, and it's been pretty much reduced to skeletal, but I am going to stay on solo for the rest of this.
It's an overall shot of the area where the head was found, and the head's actually in the photo. To the
Yeah, you
left
could have
here,
warned
I
us.
left sitting looking at it, and you see where the patrol cars had blocked off the street.
But I do see some yellow things with numbers
Yeah.
on them. What are those?
Plackets, ID team uses, they see stuff, or maybe an investigator will point out to put a placket, take a picture so they can be described later in their reports.
Fair point, Justin.
Okay.
I mean, it's not as graphic as I had thought. And I do believe this was something just right before the trial started. The state removed a closer up photo of the face out in the field or out at the scene in order to kind of gently bring the jurors into this and to not, again, try to overshock them with graphicness. So this is probably the only tame photo we're going to get.
Then,
Oh, well, I thought he,
what other items were there other than the placards?
Whether,
I'm sorry. What other items were there than the skull that you described earlier?
there was a black plastic bag. It appeared to have decomposition in it, hair, and fluids.
And was that significant to you as an investigator?
Yeah, later, when the cadaver dogs were called out, other body parts were found in the black plastic bag. And also had fluid in it that ended up being bleach.
Okay. So when you saw those pieces of evidence, I assume that was kind of the first thing that was kind of done at the scene?
Yes, I cannot legally touch any body out there. It's all up to the medical examiner. I can look at it, I can have photographs taken of it, I can note it, but that's entirely up to the medical examiner's office to do any collection of body or body parts.
Were they contacted? Did you guys contact them or?
Yeah, they came out to the scene.
Okay, do you recall who came out to the scene?
Mary Beth Happel and Dr. John Parker. The Mary Beth is an investigator for Polk County Medical Examiners, and Dr. Parker was a medical examiner.
Okay. And what did you do? What did you do next?
Well, we started. Hard to run an investigation if you don't know who your victim is, and this one's even doubly hard. We didn't know what sex the person was.
Why is that?
The decomposition of the facial and the torso, we never found it. So you couldn't ever determine a sex at that time.
And you've got to think that a skull, and the state did kind of explain it, that there are overlaps on some of the key points that they try to do for the reconstructions. If you geeked out on the John List bust, some of those, measurements can be equal for, both a male or female face. So there was kind of ambiguity in that. And then the torso is where you're going to find the most sex specific kind of bones, the pelvis, which is very sex specific in how it's shaped. Some of the ribs can be even the sizes of some of the things. Again, they do have the femur or the leg, so they could technically maybe try to guess from that. But you do have, women and men who can be similar in height. So he does bring up a point, and you'd think, okay, you have the head and, hands. Why can't you figure this out? But it's not as easy as you would think it is to identify someone, especially when remains are mostly skeletal.
The feeling is the torso contains the guts of the thing, and it would smell more, and the animals out there would have eaten it quicker.
Okay. Do you recall what the conditions were like that morning?
Yeah, I noted it.
Would you have noted that in your report?
As I rode over with Lieutenant Biello and Investigator Miller, the weather conditions to be overcast with a intermittent mist, and the temperature was in the low 60s with a brisk breeze.
So after you got there and after the medical examiner got there, what did you do next?
Nothing could do much other than make a report.
Did you talk to do you remember speaking to any witnesses?
Well, there's a gentleman who had found the head. Gentleman's just in a wheelchair, but he wasn't in a wheelchair at that time. I talked with him. I sent him to the homicide office to give a statement, and the officer on the scene took him there for a statement.
Do you recall any other actions that you did out there at the scene that day?
That day, no.
So at this point, all you had was a skull and some plastic bags, pretty much.
Yeah.
Did you find anything else on a different day?
On a different day, yes.
Were you called back out to the scene?
Yes, went back out there with the medical examiner's office. They had gotten in some cadaver dogs from Cobb County. These people who owned the dogs were not associated with law enforcement in any way. They were just citizens who trained their dogs to become cadaver dogs and would help agencies as they needed it.
Wait a minute. Is there still a citizen to, I guess, cadaver dog training facility? I guess I just assume I'm not a dogologist. So you can just take like Fry Berto, when he was still alive, and I could have trained him to be a cadaver dog. I couldn't train him to stay out of the trash can though. So, all right. Sorry, my phone, I was trying to turn off the ringer, but I accidentally fat fingered the button to turn on the ringer because I'm a smart person like that.
Who trained their dogs to become cadaver dogs and would help agencies as they needed it. And they came back out there, and that's when we started finding hands, feet, and other body parts. They were also in a black plastic bag like I described earlier, and they were always double wrapped. There was always 2 bags per body part. That kind of makes sense with me there.
And I don't know, I don't know if you said, do you recall what date you went out to the scene?
The first, it was April 29th, and then this was June 3rd.
So that's approximately, what,
A month and a half later.
month and a half later?
To get it set up.
Now, is the president, you mentioned bleach earlier, I'm sorry, you mentioned bleach earlier.
Yes.
Is that significant to collection of DNA?
Not for the collection, for the destroying of DNA.
Your Honor, you've not been given an expert notice with regard to this witness.
Your response?
Well, Your Honor, I think that's not, I think it's something that a police officer can, based on police officers' evidence collection, could probably, could testify to.
Then you would have to lay foundation that in the course of his employment, he's come to this knowledge through the foundation of this. And if it was 1999, while not completely, foreign a concept, would DNA be something that the average criminal would think about, right off the bat? Would bleach be something that, someone operating in 1998 would account for? Because you've got to also go with the knowledge that was available then. I have watched way too much true crime for this to be my opening gambit in at least 3 other points I'd like to bring up about this topic.
As within their knowledge.
Okay. If you want to lay that foundation, I likely will allow it. Overruled for now, Mr. Samuel. Go ahead.
Okay. Did you learn about bleach?
Well, DNA, it's not the same as today. This was in the beginning stages of DNA. And a lot of things would interfere with DNA. When I worked sex crimes, if there was anal sodomy, the feces would ruin the DNA and you couldn't test it. Learned that.
Okay, well, if you had any of Orville Redenbacher talking about that on your bingo card today, I'd go buy a lotto ticket. Also, if you happen to have moved head with, stick, moved skull with stick, and or baby left in laundry basket, or body parts double bagged. I think the earliest known case that utilized DNA was in the UK in 1989, possibly, but don't quote me on that. But I do believe it was in its infancy, and possibly you needed a lot more. They didn't have short tandem repeat, so I think it was relatively in its infancy, but I was still learning joined up writing during that general era, so I didn't keep up with true crime as much as I probably should have, given my futuristic career.
Bleach and
Where did you
training
learn that?
classes I took
Okay.
that would hurt DNA. Nowadays, they probably can do it even if there's bleach on
Well,
it.
what did you learn about bleach at that time?
That it would interfere with the ability to do DNA evidence with what they had to test with at that time.
Your Honor, at this time, I believe I laid the foundation based on his training.
And we still then never got notice of him being an expert. So if he's giving expert testimony about DNA, you're entitled to be given notice of that.
Okay. I understand your objection, but it's going to be overruled, and to the limited extent you've been asked the question, I'm going to let him answer it. Go ahead.
Thank you. I think he's already answered it.
I think he has.
Okay. What did you do? After you went out and in June, what did you do next on this case?
There's nothing I could do until, again, you can't start much of an investigation until you know who the person, what sex the person is, who the person is. You have nowhere to start. So Investigator Miller, who worked adult missing persons, is assigned to homicide. She would attempt to identify the body. Medical examiner's office was trying to identify they could hook up with other medical examiner's offices and do the thing, and hook up and see if they had any information. I retired in 2000.
Okay, well, and that was, you never got an answer by the time you retired?
No.
Okay.
Yes.
I just have one more.
Sure.
Fair point.
Nothing further, Your Honor.
Thank you. Mr. Samuel?
Detective,
Well, that's not entirely true, Justin, because he went to then work for the Douglas police. So he retired from Atlanta and moved to Douglas County. And then I think maybe retired from there in like 5 years ago. I don't look, I kind of got sidetracked with his whole comment about DNA and the various ways it can be destroyed. I'm gonna have to look back at my notes.
Kelly, my name is, it won't happen a second time.
That's okay.
It won't happen a third time. Detective Kelly, I don't believe we've met before, even though we've been around a long time together. So a couple questions. First of all, you said something about a dog on the scene. Do you have any reason to believe that that dog had ever moved the skull at all?
I believe so. I believe the dog drug it out of the woods, and
Or you're just speculating about that?
there was a video, VHS recording.
Can you stick with the microphone?
There was a VHS recording at one time that showed the dog dragging the bag out of the woods. Now, I don't know where it's at
Dragging the
now.
bag with the skull out of the woods?
Yes,
There was no detectives out there until after the skull was already there.
VHS recording. That's a security camera. It's so old. It was
Where's the evidence of that?
Okay, I was like, who is standing out there? Because I'm thinking with like a camcorder, like dad's got the two arms on it. Okay, all right. Okie dokie.
I'm sorry.
Has anybody ever had evidence of that? Is that in any police report anywhere?
I don't know.
Are you just kind of making it up today?
No.
I've read every report you've ever written, every report every other detective has
You haven't
written.
written all written. There are reports missing. I don't know why, but there are some reports missing.
Have you told the DAs there are reports missing?
Yeah. But I mean,
Which DA did you tell that there are reports missing?
gentleman here just questioned me.
Uh-huh.
Jesus, Fulton County. What the? You know, we got through one witness by destroying a microphone and having to have him sit by the podium. This is going well.
I had more reports in this file, and they're not.
And
nowhere to be found.
where's the VHS?
I don't know.
Did you tell them there was a VHS recording that's missing? You told
Yes,
Mr. Wilson that? When did you tell him that?
the other day when he called me.
You told him the other day?
Sir?
You told him the other day?
Yes.
Is there a
Called
reason?
me last week. Yeah,
And what else did the recording show?
just that.
Did it show how the skull got there at all?
Just what I described.
A dog pulling it out of the woods. Where from what part of the woods? Well, it's not in your report, you know that.
I'm telling you, I have reports missing out of this file. This is not my whole file.
Take your time.
It's from a wooded area where we returned with the cadaver dogs. It was coming from that area where the other bodily parts were
Chloe, how dare you?
What did the dog look like?
found. Like it was a stray dog. The hair was all matted and nasty looking.
Was there any dog hair found on the skull?
I don't know.
Was there any testing done of the skull to show that a dog had moved it?
I don't know how you do that because remember the black plastic bag? It was ripped open. The dog was toting the bag and it fell out.
And you saw a video of that?
Yes,
What did you do with the video?
it was put in evidence.
I think we need to take a break and talk to the district attorney's office for a moment here.
Okay. Ladies and gentlemen, I'm going to ask you to step out for just a few minutes. It's 2:21. I'll try and get you back in here as quick as we can. Thank you all.
All right, for the jury.
Well, you guys, this is actually a good place to kind of stop it right now. I am actually needing to take a break and stand up because my leg is kind of doing that thing where it's telling me that I have exhausted its good graces for today. That being said, so let's see how many pages of notes. About 15. And I I don't even know where to go with this case as of right now. We have had between you know, oh, we're going to bring in the fact that her father's a serial red rummer and her mama helped, like shake and bake, from the defense to the discovery issues to now of missing videotape to skulls being moved with sticks to freaking a juror needing daily in-home dialysis as you do. Uh, tomorrow is gonna be a good day. I would suggest we all go get sanity saving Mike and Ike's or whatever snack food of your choice will save your sanity for tomorrow because what in the Walmart rapture times two? This is cubed. I don't even know what is going on here. Thank you guys so much for hanging out with me as I try to wrap my head around this incredibly insane case. I am all the confusioned. I this case is just all of the things wrapped into one, but I like it because it allows me to go through all different sort of thought processes and kind of interrogate the idea from different perspectives. And I do like that because then I can really kind of question if I have any biases with how I'm looking at this trial. Because I tend to be able to argue, regardless of moral repugnance, both sides of the cases. Now, except for Sarah Boone and notable others like Shanda Vander Ark and well, Letitia Stalk, but that's because they're indefensible. But I usually can follow the logic train that they had to have run on to get there. Now, I am sending you over to Flux, give her some love. And I will see you guys tomorrow with Mornings with Mo. And then tomorrow is Wednesday night, so it's Koberger night. So we are going to be continuing to dive into the newly released documents with the caveat that I will be working on a video. It looks like Madison Mogen's mother, I do believe, do not quote me on this because I have just barely pulled it up, does seem like she put in a stop order to disallow any more crime scene photos of. Now, per the order, it does look like it's only Madison's room, but oh, and the Chapins. And I have always been of the opinion, true crime or otherwise, there's a family left behind, and whatever we could glean just from curiosity, I think the documents are fine. These families are already having to deal with the loss of their children and the fact that their children have now become kind of culturally, culturally, they've had to share their children with us, share their pain, share all of these intimate details about, the crime scene. I think that it would be okay. And I think that most true crimers would say, we don't need the graphic photos. We don't need to hurt the family any more than Brian Koberger did. And that's the part of true crime I play with. So I'm hoping that the court, and I do believe the court, the judge, and the state can work together to make it so that things that the family are going to find repugnant to be out don't need to be out. In my opinion, there's nothing gained from releasing something that's going to hurt the families like that. I will say I was really impressed with the way Idaho has handled everything thus far. So I I feel okay generally that the state, the judge, and all parties involved will be able to come up with something that gives the public what they deserve to know as, this being a public justice, kind of, or function of justice, but also allow the families to not have these images just flash up at random or be, fodder for sensationalism. At least that's my thoughts. I think that, there can be a balance that is achieved. I have a lot of questions about her, but it's mostly questions like why do psychiatrists always go into psychiatry to try to figure out what's wrong with them? I don't know. There's something very, very wrong about her self-insertion very close to the case, and kind of her desire to want closure on this on a level that I think is a little odd. I think she's more upset that she didn't see anything, or didn't notice that he was troubled when she was teaching him. But I don't know. Tomorrow is Koberger today. I am going to go detox from all the crazy of this case and then go see how the defense's opening statement was handled, or at least received by some other general audiences, because I do think that they run the risk of, again, it's kind of within every decent person's DNA that we don't want to pile ish on top of victims or, surviving family members. So it's a delicate balance that he has to kind of achieve to put this, this doubt in. It is called a Viva Lift, Sarah Adams. It is super comfy, pricey, but the luxury to be comfortable for longer when I'm streaming is definitely going to be nice. So it's really nice, and I'm very lucky to have it because office chairs are not the easiest to find a comfy one in. But I will say I really like it, and it's definitely been worth it to just be comfy. So have a great day. I'm sending you over to Flux. I do believe that Squid Pro Quo is also covering a hearing in the TikTok murders. And if you would just like to stick with this case, Baker is covering current time. So we're in the past, but current this trial. So you do have options available to you. Be kind to yourself, be kind to others, but have a sassy mouth and carry a can of bitch fire, because I'm guessing locust for tomorrow for this trial. I don't know which one of the deadly plagues we're going to be on, but at this point, I only foresee more and more shenanigans until they get absolutely biblical. So I'm going with locusts. Bye, you guys.